Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome, welcome, welcome. Welcome back if you were here earlier for Murdoch. We are back for more with Shanna Gardner this time. So there was a hearing yesterday. I mentioned it actually at the Brian Kober live stream last night, where there's all kinds of tech issues and prosecutorial misconduct and plenty of that's what she said opportunities. Also, we're going to hear mention of a tech expert, a Mr. Green. They don't give a first name. Is it the same tech expert from Karen Reed? We don't know. That remains to be seen. But plenty of exciting things going on there. And also, we have some new court filings to get caught up on that came out subsequent to this hearing. So we're going to start there. So first up, we have filed from February 12th. All right. We have, okay, background here real quick. So Henry Tenon. So Henry Tenon is the alleged hitman, if you will, right, for this case. And they connected the murder of Jared Bridegan to him, right? Law enforcement did. And they brought him in, right? And he sat in the interrogation room. That has not been released yet. And he made the plea deal of all plea deals, basically. And essentially what happened recently was he was at a status hearing, right? And he basically interrupted like the proceedings and was like, hey, you know, I didn't say this. He essentially what it boiled down to was it was a false confession. He was like, I didn't say this. I didn't agree to this. I didn't, you know, yeah. So, and it was a whole thing, right? And then we watched it and everything, and his counsel was brought in, and you know, they were basically like, it was really kind of offensive. Like, he's got a public defender, and his public defender was like, look, he doesn't know what he means. I know better than he does. You know, Anyway, we covered all that on the previous Shanna Gardner live stream. So it's a big mess. Because what the state has here, right, is not a whole lot. But one of their big things was supposed to be these checks that were paid to Henry Tenon for the alleged hit job, right? Well, it came out in Shanna Gardner's second bond hearing that the state had misrepresented the year of those checks, and that those were paid to Mr. Tenon for the month that they were representing, but the previous year, and it was for legitimate work because he actually did legitimate work for them. And so that basically obliterated the money trail that the state was hoping to improve. And the other thing they had was this his confession, Henry Tenon's confession, where he's the one that said, you know, they hired him, but now he's recanting that. So basically, there's all this fallout happening. Okay, so the first thing was the defense teams here wanted, you know, they wanted disclosure of Henry Tenon's jail calls. So this came out again on February 12th. So this is the order granting the disclosure of the co-defendants' jail calls. So, so the Jacksonville Sheriff's Office shall release any and all jail calls made by the co-defendant Henry Tenon since his last arrest to both Patrick Carodi. That's the lead. These are the lead defense counsels for Shanna Gardner. Shannon Day, I'm not quite sure. Maybe she's with, she might be with Mr. Dreiser, who's counsel for Mario. Twiz, you silly head. Welcome, Twiz, our one and only mod / co-host as of yesterday. Big news, big news, big news. So basically, there we go. So they are disclosed. They are going to get those jail calls. Okay. So next up, we have from February 27th. Guess what? More sanctions. Woo! Defense motion for sanctions due to continued discovery violations. So they move this honorable court sanction to provide relief based on the state's cumulative discovery failures. In this case, its failure to disclose favorable evidence to the defense as soon as practicable. Let me zoom in a little bit here. It's violations of court orders regulating discovery and the cumulative effect thereof. And they state the following. She stands, okay, so there's her indictments. We don't need to read all that. And by the way, for anyone who's new to this case, this is a death penalty case for both Shanna and her estranged husband, Mario. So the court is aware, and the record captures repeated discovery delays and violations solely attributable to the state attorney's office. These include the failure by the state to perform an adequate taint review. We talked about taint yesterday, I believe. If anyone is not sure what that is, let me know. Of Ms. Gardner's devices to remove attorney-client communications despite assuring a judge it would do so, and the involvement of a prosecutor in this case providing legal advice to the law enforcement agent reviewing the attorney-client communications. So all of this already happened, right? The potential spillage of attorney-client communications to all law enforcement and counsel in this case due to, at a minimum, a lack of prosecutorial oversight into the use of an online e-discovery tool called NextPoint. The repeated disclosure of voluminous materials resulting in confusion and delays among the defense counsel working to diligently prepare this case for trial, which, by the way, it's supposed to go to trial in October, and the lack of labeling or listing discovery materials disclosed. State Attorney's Office has repeatedly and without consequence abused its authority. Recently, Ms. Gardner discovered that the prosecutor issued an ex parte investigative subpoena to JB, an alleged unindicted co-conspirator. Huh? I don't know who that is. Oh no, that's got to be what's her face, her friend. What was her name? No, Kim. It's not Kimmy. There was Kimmy. Huh. I don't know who it is then. An alleged unindicted co-conspirator to appear at the state attorney's office on June 2024. Huh? Okay, footnote 1. Who the fuck is JB? Ms. Gardner recognizes that the ex parte subpoena was issued under her co-defendant's name and case number, but this is a distinction without a difference. To hold otherwise would permit a prosecutor to circumvent a clear legal right of the defendant to be present for a compelled examination of a witness on the matter. So, okay, it was filed under Mario. Who is JB? So I wonder. Give me just a second. Let me see if I can find this because I wonder if they don't use the initials, but they use the actual name. Because who the fuck is this? Let's see here. Let me just see if I can find this. Twiz is welcome to jump on if he wants to. And it's funny because they have it. Let's see. Trying to find it here. Why am I not able to find it? Hold on. Maybe they took off the Saldana. No. Weird. Let's see. Let me try it this way. I can pull it up through Shanna's thing. No. Go back to that. Yeah, I don't know why this is being difficult. Hold on. Well, what I'll do is this. I don't know why I'm having a hard time pulling it up. What I'll do is this. I will look into this further to try to find the document with JB while we start playing the hearing. We'll do that. I'll come back to it because it looks like it was. Oh, shout out to everybody who's here in the chat. Sorry, I was looking for these documents. Shout out to Black Witter. Shout out to Meg P. Twiz, why are your hands cold? And Black Witter, did you finish your move? I believe that was yesterday that you were moving. Meg's getting her family ready for lunch. Twiz, you've been here for previous. You don't know nothing about this case. You've been here for previous live streams. By the way, we do have a new command, guys. You can do !weather, and then you can type in your city and state or your zip code, and it will give you the weather for where you live. We also have this one where if you type !DJ, it puts in a random quote from DJ Khaled's Keys to Success or something like that, which is pretty funny. Shout out to P. Fox, who's driving but here. So yeah, DJ Khaled once said, do you see that bamboo? Ain't nothing like bamboo. Bless up. Perfect. Love it. Excellent. I love that. Okay, so we will come back to JB. And Blackwater, you might need to be more specific. I'm not quite sure how it works for other countries, but yeah. Okay, so JB, an alleged unindicted co-conspirator. Okay, the state, so what the fuck? Okay, the state has disclosed no reports, notes, or other documentation memorializing this encounter. The subpoena, which is attached here too, was found this month. Oh, good. It's attached here too, so maybe we'll see there. In a folder containing unrelated toll records. It was never listed on a discovery exhibit and was only found by happenstance in the disorganized, voluminous discovery in a folder that appeared to be, at first glance, a redisclosure of certain material previously disclosed. Most concerning is that such use of an ex parte subpoena by the prosecutor was illegal because Ms. Gardner listed JB as a defense witness on December 2nd, 2023, and Ms. Gardner received no notice of this compelled witness examination. Oh, dear. Ms. Gardner has been prejudiced because she has no clue as to what information JB provided to the prosecutors during the June 5th, 2024 examination. This ex parte subpoena was issued on June 3rd, 2024, and on the heels of the court's admonishment to the prosecutors about their handling of the discovery in this case following Ms. Gardner's motion to disqualify the state attorney's office. The court wrote in its orders that prosecutors are to govern themselves above the conduct of other lawyers, that their prior taint procedure was flawed in almost every respect and improperly executed, that they failed significantly in implementing the taint team, and that they acted naively and exercised poor judgment. Mother of God. And honestly, that's an understatement, to be honest, with what this prosecution's been doing. Less than 1 month after these admonishments, the same prosecutor subpoenaed JB without notice to Ms. Gardner. The prosecutor's behavior has transcended from what was characterized by the court as poor judgment to outright disregard for the rule of law. Wow. Wow. Black Widow stayed in her new house last night. That is amazing. I love that. I love that. Yes, Twiz is now got, like I said yesterday, what is it? Constitutional rights. He can pop on whenever he wants, and he can also pull up comments and do all kinds of things. Super fucking fancy. Very excited. He deserves it. So, and by the way, of course, one of the reasons I'm covering this is because Jose Baez is Shanna Gardner's lead defense attorney, and y'all know he's my absolute fucking favorite. So, this, of course, was not the first time the prosecutor unlawfully issued ex parte subpoenas. It issued ex parte investigative subpoenas citing Section 2704 of Florida statutes to compel witnesses outside the state of Florida to appear solely before law enforcement and to appear at places outside the Fourth Judicial Circuit, providing no legal authority for such action. These legal investigative subpoenas were not turned over in discovery until Ms. Gardner filed a motion to compel on August 24th, 2024. And we've covered all these previous filings. The state attorney's office has used heavy-handed tactics with defense witnesses. The state attorney's office aided and abetted law enforcement officers in intimidating witness KG, that's Kimmy, by serving an ex parte subpoena in a public supermarket parking lot for her to immediately appear at the state attorney's office in July 2023, which ultimately led to her being escorted by numerous law enforcement agents to the state attorney's office, where she was threatened with arrest for murder by the prosecutor. That shit was crazy. That second bond hearing was unreal. The state has disclosed no reports, notes, or other documentation memorializing this encounter through the purpose of the subpoena is for the witness to appear and provide sworn testimony. Whose name is Pierce? Oh, his name is Pierce. Oh, that's nice. Oh, that's so cute. He's waving at Twist. Aw, cute. The state attorney's office and its agents have failed to disclose favorable evidence as soon as practicable as required by the rule. The clearest example is the recent spontaneous announcement before this court by Henry Tenon. Here we go. This is what I was just referencing at the beginning of the live stream. So this is the alleged hitman, right? By Henry Tenon on January 13th, 2025, that he had provided false testimony. And when it got around to disclosing it, the prosecutor proverbially buried it with other materials, leading to this court admonishing the prosecutor to clearly identify such materials in the future, with the prosecutor repeatedly trying to dismiss the court's and the defense's concerns over how the disclosures were being made by the state. The prosecutor in this case was aware at 9:30 a.m. on January 13th that the state's star witness, Henry Tenon, characterized his sworn statement incriminating the defendants in this case as false testimony in open court. There can be no ambiguity in this assertion, as the discovery has not disclosed that Tenon has provided any testimony other than a recorded sworn statement made on March 15th, 2023 by the very prosecutor who participated in his June 13th, 2025 court hearing. And by the way, I called it, dude. Before he came out and said this, Henry Tenon, we are watching that second bond hearing, and I have it timestamped. I literally said, you know what? I bet this was a forced or a false confession, because he has a previous record, a criminal record, and they gave him the deal of a lifetime, like on par with like a Katie McBanoa, and like literally everything about it didn't smell right, especially when they came out with the dates on the checks being wrong. That was when it clicked for me, and I was like, you know what? This is a fucking false confession. And so then this happened, and I was like, oh my God, incredible. The transcript of this hearing was completed on January 21st, 2025. The transcript was then disclosed to the defendants unlabeled with more than 80 other files on February 5th, 2025. Happy Annie's back. Welcome, welcome. Wow, look at all these footnotes that are carrying over from the previous page. Okay, we're going to keep going. So then in open court on February 7th, 2025, Ms. Gardner became aware that a meeting took place between Tenon and the prosecutors following the January 13th, 2025 court hearing. Jail records indicate that Tenon was taken to the state's attorney's office. Right, that's right. This came out in the hearing too. This is insane. So after he had this outburst in court where he said it was a false confession, basically, they took him to the state's attorney's office, the prosecutors. This is insane. The next day. And this was arranged by his defense attorney, who's basically like, he doesn't know what he's saying, and I know better, which is why it's just gross. Tenon also went to the state attorney's office on February 17th. 615 minutes. Wow. That's how many hours? Many, many hours. Wow. Oh my God. When questioned about this, the prosecutor stated to this court, prosecutor, we don't have any statements from Mr. Tenon in that meeting. Court, okay. Prosecutor, that we need to disclose. Court, okay. Prosecutor, we understand the rules. They do not understand. That is a fucking lie. I'll tell you right now. They don't understand the rules. This is crazy. Crazy. Oh my God. Oh my God. Okay. Let me go back up. This is wild, you guys. The state has disclosed no reports, notes, or other documentation memorializing this encounter, despite common sense dictating that a discussion regarding Tenon's apparent recantation must have taken place. Whether Tenon maintained his testimony is false or again reversed himself, such statements constitute material evidence that must be disclosed to Ms. Gardner. So what they're saying here is they don't know what happened in this meeting where they met for almost 2 hours, and then what, like five or six more hours the next day, where they don't know what happened. Did he say that the false confession, when he said it was a false confession, that was false? Like, did he reverse it? Did he say, like, what did he say, right? But regardless, it needs to be disclosed. This is insane. This is insane. How the fuck have they? Okay, calm down. Keep reading. Don't go so Meg doesn't go away. It violates all notions of common sense. Yeah, that an extensive meeting took place the day after Tenon's statements in open court, and Tenon said nothing to the prosecutor. Right. So in other words, if he didn't say anything, there's nothing to turn over. But obviously that's not what happened, right? That's why, and we already read that footnote. On or about February 10th, 2025, the state attorney's office coordinated the upload of unfiltered device extractions for the defendants to evidence.com. So remember, this whole case started out with all these leaked attorney-client privilege information that the prosecutors not only leaked it, but it was disseminated, okay? And there was all these initial hearings about that. And then they had to come up with a new system. Their new system, and we're going to hear all about this, guys, in the hearing from yesterday, evidence.com, which every time I hear that, I think it's fucking hilarious that it's called evidence.com. So this was their new and improved system, supposedly, right? So you're going to hear about that in the hearing. So unfiltered device extractions for the defense to evidence.com, a file sharing platform used by the state attorney's office. On or about February 17th, 2025, Ms. Gardner's counsel became aware that the state had provided copies of her unfiltered devices to her co-defendant's counsel. Ms. Gardner and her co-defendant have repeatedly brought to the court's attention the prosecutor's lackadaisical approach to discovery, its failure to abide by its discovery obligations, and its failure to protect the rights of the defendants. Footnote 7. Okay, that's just some Brady shit there. All right. Admonishing the prosecutors in this case is not working. Clearly, this is wild. And this court must now sanction the prosecutors for their repeated and continuing discovery violations and failures. Footnote 8. Okay, right. Basically, don't be dumb and don't be fuckheads, essentially, right? Don't commit fuckery. Don't engage in fuckery, state. Ms. Gardner seeks the following sanctions and relief. A, prohibit the state, with prosecutors and law enforcement, from obtaining any search warrants or issuing any subpoenas in this case without first providing notice to Ms. Gardner. B, order the state to turn over any and all notes related to ex parte encounters with Tenon, KJ, and JB. Who the fuck's JB? Prohibit the state from having any ex parte encounters with Tenon without first providing notice and an opportunity to be present. Authorizing Ms. Gardner to depose Alan Chipperfield and Matthew Bodie, Tenon's attorneys. Now, Chipperfield, remember when I said that Tenon's public defender or whatever is like really sucks, and it's like really, like when you think about like the quintessential like what I feel like is usually people's interpretation of a public defender when they call it a public pretender, where it's like literally they're basically just pawns for the state, right? And they're like and luckily we don't see that very often. We're used to seeing actually public defenders that are killing it, right? This Alan Chipperfield literally is the first type. It's really disgusting and gross and sad. So that's who Alan Chipperfield is. And again, we watched that hearing on the last Shanna Gardner live stream, and it was just so offensive, where he's like, Tenon, he doesn't know, like, I know better, and da-da-da, right? So Tenon's attorneys regarding the meetings at the state attorney's office between Tenon and the prosecutors order the state attorney's office to pay Ms. Gardner's cost associated with litigating this and any further discovery issues in this case at a rate of $500 per hour. Footnote 9. Look at that. There he is. Jose Baez. We love you. Couldn't agree more. Don't be a fuckhead, state. It's that simple. Yep. And so that would be the sanctions, right, to pay for it. The Baez law firm. Freaking law firm. Now, it said there's a subpoena. Here it is. Fuck. We're not going to know who JB is. It's redacted. God damn it. God damn it. Who is an unindicted co-conspirator? Who is, I mean, completely changes the case, right? Like, what on earth? Now, this is kind of Adelson-y too, right? Because like in the Adelsons, there's all these unindicted co-conspirators that slowly but surely have been indicted. But there's been no mention of anybody else being involved. This is crazy. This is crazy. All right, next up, we have, this is the next one before we get to the hearing. State's response to defense motion for sanctions due to continued discovery violations. And boy, oh boy, the lead prosecutor in this case, which is Mr. Mizrahi, he has such a fucking attitude. It is wild. It is wild. And then you have ADA Stifler, and she's also, she could go ahead to have the Ashley Jennings guys, honestly, with which one's worse. It is really crazy. So, okay. So state's response to the defense motion for sanctions due to continued discovery violations. All right. Procedural history. On February 27th, 2025, this is the document we just read. The defense filed a motion for sanctions. In defendant's motion, she reasserts several failed claims and allegations she has presented to the court in previous motions and hearings, which were otherwise ruled upon adversely to her. She attempts to recast these previously failed claims as continuing violations, in scare quotes, in her effort to justify her claim for sanctions. Defendant's claims and allegations can expeditiously be disposed of during this case management conference or a teleconference between the parties in advance of March 28th. Requested sanctions are not awardable or warranted. The defendant's claims and allegations do not give rise to the award of sanctions. So here's the rule. I'm not going to bother reading those. I mean, it's clearly sanctionable, but anyway, we're going to watch the hearing. So the subsection 1 speaks about inadvertent discovery failures. Subsection 2 speaks to an award of sanctions and specifically states contempt proceedings. Before proceeding with an examination of the specific claims and allegations raised in the defendant's motion, it is informative to review the defendant's requested sanctions in light of the previously mentioned discovery rules. In doing so, it becomes apparent the defendant's motion does not seek sanctions so much as it seeks to interfere with or impede the state's continuing investigation into the murder of Jared Bridegan and the state's criminal prosecution of the defendant for his murder. Twiz is trying to guess something. Let me see. What is the question here? President Hoover? Wasn't there a Hoover president, dude? Hoover? That's my guess, just looking at what you guys are saying. So the Florida statutes provide legal requirements for obtaining a search warrant in Florida. As enacted by the Florida legislature, there's no advance notice requirement. The same is true for Chapter 27, which authorizes the issuance of an investigative subpoena. The plain reasoning behind the absence of a notice requirement for a search warrant or investigative subpoena is to prevent the destruction or movement of evidence of criminal conduct. It is uncontroverted that the weapon used to murder Jared Bridegan has never been recovered. Should evidence arise prior to trial as to the murder weapon's location, it borders on incredulity to suggest the state would be required to notify a defendant charged with the murder of the existence of or issuance of a search warrant for the murder weapon. I don't understand what they're talking about. There was no talk of a search warrant for murder weapon. They were talking about a subpoena for an unindicted co-conspirator. What is happening? Oh my God. By virtue of his plea agreement, Henry Tennant has become a witness the state intends to call at trial. Tennant has been represented by legal counsel since his arrest and his subsequent entry of a plea to second-degree murder. And again, it's sad because it's like just his defense is like a shill for the state. It's really gross. Like any other witness, he will be subject to deposition by the defendant and to cross-examination at any future hearing or trial. Welcome back, Scott. Happy to see you again. It would be legal malpractice for the state. It would be legal malpractice for the state not to meet with Tennant and his counsel in advance of any future deposition, proceeding, or trial. There is no requirement in the Florida Rules of Discovery that the defendant's counsel be provided notice of any meeting between the state and any witness listed by the state or otherwise have an opportunity to be present during such a meeting. Conversely, the same is true for the defendant and any of her witnesses. And then this is the part where it says what the defense is asking for. The relief the defendant requests does not require any ruling by the court. Attorneys Chipperfield and Bodie have not been listed as witnesses in a state discovery exhibit. And they're citing the rule. I mean, this is just dumb. The defendant's request presupposes that notes exist regarding ex parte encounters. Moreover, there's no requirement in the law the prosecutors take notes of any such encounters or disclose such notes as a matter of course. Attorney notes are often protected by work product and are generally not discoverable. Lastly, the defendant seeks reimbursement for costs associated with litigating this, in scare quotes, and any other further discovery issues, in this case, at a rate of $500 per hour. And then they're saying because it's sanctions, they're like, it doesn't amount to sanctions, basically, right? Claims and allegations. So setting aside the arguments that much of the requested relief the defendant seeks is either unavailable to her or otherwise unwarranted, the substance of the defendant's claims and allegations do not warrant relief. This is true whether examined individually or framed as an alleged pattern of discovery violations. Prior alleged discovery. Alleged? Is this a joke? I'm so confused. Oh my God. So it's not a Hoover. I don't know presidents' names either. Hoover, I thought was a president, but maybe not. Presidents start with H. Yeah, I don't know. I have no idea. The defendant first sought to utilize alleged discovery violations as a basis to disqualify the state attorney's office. The court denied her request to disqualify the state attorney's office. The basis of her allegations related to the initial taint review continues to remain under the supervision of the court and is ongoing. And further issues arise, which we're going to hear about here in a second. She then sought to utilize alleged discovery violations as a basis to be released from custody. I almost said custody. Oh my God. Interestingly, in her motion for bond, she acknowledged the state's due diligence in discovery by stating, due diligence. I'm sorry, I can't I literally cannot with this. I cannot with this. This is just horrifying. Okay, let's get to this part with JB. The defense claim that the state inappropriately issued an investigative subpoena to JB is without merit. They didn't issue a subpoena? What? What? Oh, thanks, Blackwater. I love it because, you know, Blackwater joins us from the Republic of Ireland and knows way more about people in the US than I do, which is great. So shout out for education. Shout out to education, rather. Okay, there's the rule again. They already noted that. It is not per se improper for the state to issue an investigative subpoena to a listed discovery witness. In this case, JB has been listed by both the state and the defense on their respective initial discovery exhibits. And then there's the case law. Dude. Similarly, the defendant has deploy the same tactic disapproved by the Supreme Court. The defendant knows who JB is and can interview him in the same fashion as the state. She may have already done so. JB has told the state he has nothing to say and denied knowing anything about the murder. Based upon information and belief, he would likely refuse to testify as a witness if called to testify. As such, the defendant's claim regarding the issuance of an investigatory subpoena is without merit. Much like her claim regarding the issuance of an investigatory subpoena to JB, the defendant's claim regarding the issuance of an investigative subpoena to KG must fail. KJ is listed as a discovery witness for both the state and the defendant. They're mentioning the grand jury testimony, which is hilarious. Oh my God, what a mess. Okay, this part's interesting, though. Even if the state had committed a discovery violation in failing to disclose these statements and circumstances to defendant prior to the Arthur hearing, defendant is not entitled to any additional relief because there was no prejudice. Defendant already knew Kim Jensen was a person with knowledge of the case. Additionally, defendant was in possession of Kim Jensen's prior recorded statements to police and the grand jury. Those statements disclosed that the defendant's statements about Jared Bridegan were a form of venting frustration with her friend group. Even without the prior recorded statements, is a reasonable inference from the contents of the text messages that they could be jokes, based on Ms. Jensen and defendant's use of euphemisms, emojis, and interjections. Defendant was obviously aware of the possible explanation because she crossed Detective Johns about and argued to the court that the text messages were not serious. Considering this context, there's not a reasonable probability that defendant's preparation for and presentation at the hearing was materially prejudiced in her, and she learned of these statements. What? Discovery related to co-defendant Tenon. Lastly, the defendant's claims of a discovery violation regarding Tenon's in-court statement must fail. Tenon's in-court testimony is the subject of a demand for specific discovery. The state disclosed the existence of Tenon's statement and provided a transcript of the statement to the defendant. Yeah, but not without some back and forth to get that to happen. On February 7th, the court heard further argument from counsel. The court permitted counsel to question Chipperfield in open court. And yeah, and that was what pissed me off because Chipperfield is just an embarrassment to the profession of being a defense attorney. Oh, God. It is just, do we learn who the H dude was yet? I don't think so. Defendant's claim for relief is premature and now moot. Okay, wow. Wherefore, based on the foregoing, the state of Florida requests that the court deny the defendant's motion. All right. And the case management hearing on March 28th. That's the hearing from yesterday that we are about to watch. And oh, Hank is a good guess. That's a good guess, Twiz. Okay, so first of all, though, I have a quick little treat for you guys. Just saw this by happenstance. Let me unshare, reshare. Like this just popped up on YouTube right before I went live, and I was like, what? This is Greensboro news, local news to me, guys. Man accused of indecent exposure at Greensboro Walmart. So let's watch this together and see what happened at this local Walmart in Greensboro, where I live.
Facing charges after allegedly exposing himself inside a Greensboro Walmart. I'm Michael Hennessy. This is the Fox 8 5 O'Clock News.
And I'm Natalie Bolson. According to warrants, a 24-year-old man was taken into custody yesterday. He's accused of exposing himself at the Walmart on Elmsley Drive in late February. Fox 8 Celeste Smith joins us now live in front of the Walmart where this incident reportedly happened. Fox 8 Celeste Smith is there. Celeste, what did you find out after you're speaking to one of the alleged victims? What did she say?
Well, the suspect that is facing those charges is Adrienne Cooper. And I spoke with Victoria Gray, and she says she was left shaken up after this incident. She says she was with her son's 14-year-old girlfriend inside of the store when she said that Cooper was allegedly following them while he was exposed.
When I looked up, I saw him on the opposite side of us, and I saw him staring at her. So I said, okay, maybe he's trying to find the same thing we are, so I'm not going to say nothing or make it a big scene.
Victoria Gray was just looking for cleaning supplies at the Walmart on West Elmsley Drive. While there, she noticed a man dressed and behaving suspiciously. She would later find out police identified that man as 24-year-old Adrian Cooper, and he's now facing indecent exposure charges. Gray says Cooper repeatedly passed her, and she realized something was wrong.
I said, yeah, I know you're only a kid, but you need to open up your eyes and pay attention to your surroundings, because I said there is this man who's walking around with see-through leggings and showing us his body parts.
Oh dear.
She says she confronted him.
You know what? I told him, I said, I done seen you too many times in this store. I said, if you not a secret shopper or you don't work here, you need to stop following us around, because I said, I'm getting ready to get the police up here.
Soon after, she says other women in nearby aisles came looking for security, reporting the same thing.
He went back down the women's aisle somewhere. Security and another few of the men came from out of the camera room and all kinds of things, because they said that they had seen him following numerous of women around the store, maybe about 5 women in total.
Gray says she called 911 and Greensboro police responded.
I seen wearing gray hoodie and see-through leggings with dreads and ponytail. I seen, and possibly in the PVA, employees chased him out.
In addition to facing charges for indecent exposure, Cooper is also facing charges for failure to appear in court. His bond is currently set at $1,000, and he is still currently being held in the Guilford County Detention Center. Live.
Local news, guys. Indecent exposure at the Walmart. There you go. That's the story. Okay, so now we're going to get to the hearing. Also, big news as well, guys. That I have, guess what, court filings for Lori Vallow, and they include her motion to dismiss for like prosecutorial misconduct or something insane, and also like her handwritten motions about being able to wear civilian clothing and like not being shackled and whatnot, and some other things. And so, and then there's also, Nate Eaton did an interview with Colby, Lori's son, surviving son. So we're going to probably do that one tonight. I'll have to sort of see if we want to do BK. But anyway, that's just exciting because the Lori Vallow docs are not easy to get. And so I was like, had to do a couple little scroll tricks to get them. But yeah, because they're starting jury selection in like, I guess on Monday. And then they're expecting opening statements to start on April 7th. And in case anyone's like, oh yeah, what's going on with that? So she's in Arizona representing herself pro se. So that will be fun. So we will do that as well. Yeah, sorry I missed it, right? Totally. I'm always down for a good shit show, right? Like I'm always down for a good shit show. Definitely sorry I missed it for sure. And in fact, I'd never even heard of Elmsley Drive. I just had to look it up. I'm like, where the fuck is that? It's like 20 minutes away. The interview was amazing. I actually haven't even watched it yet. So I'm really excited. You guys will get my first impression on that. So, but I'm not surprised. Colby is awesome and he's been to hell and back. So, so yeah. Okay. So here we go. Now the audio on this is, well, yesterday it was, I don't know if they've done anything to fix it. It's terrible. You know, it's touch and go, right? Hit or miss with court shit. So, but it's going to have the closed captioning on. We're going to do our best, but this is literally First Coast News is the only place that has these, unless it's like one of the major things like, but anyway, for the hearing yesterday, this is the only place that has it. So, and there's Judge Kite. So we are going to take a look here. If anybody has any questions, let me know.
Thank you. Good morning.
We're in, by the way, we are in, just to orient y'all, we're in Duval County, Florida, which is like, fuck, where is it? Fort Lauderdale? I don't even fucking remember. It's Duval. Everything's done by county, right? With the court system. So let me just see. I think it's Fort Lauderdale. Jacksonville. We're in Jacksonville, Florida. We are in Jacksonville, Florida. That's where we are. Okay.
Good morning. Give him just a moment.
Wow.
The Zoom
Twitter.
situated. Okay. Good morning.
Christina Stifler and Mark Khalil on behalf of the state. We're ready to address number 2 on the court's calendar, Mario Fernandez Saldana. Number 5, Shanna Gardner.
Okay.
Oh, Mr.
Morning.
Mizrahi's not there.
Patrick Curry on behalf of Ms. Gardner, Mr. Baez, and Ms. Peoples are present via Zoom.
Thank you. Good morning.
Mr. Baez is there via Zoom. Yay! Love him. Oh my God, sorry, that was him. That was his voice. I'm just such a fan of Mr. Baez.
5, Shanna Gardner.
Okay. Good morning.
Good morning, Your Honor. Patrick Curry on behalf of Ms. Gardner, Mr. Baez, and Ms. Peoples are present via Zoom.
Thank you. Good morning.
Good morning.
Good morning.
Yeah, court is the volume's terrible. And I don't know if I think it gets better at certain times. Mr. Baez was loud and clear. What I will do is I will turn myself down because I have it to automatically I'll turn myself down, and that way you guys can turn it up. Because there's nothing else that can really be done. So that way you can turn it up on y'all's end. Let me see if this helps. So I just turned myself down. I mean, I have it all the way up, but it's just court is what it is.
So we're here on several motions and also a case management hearing. And I'm interested in y'all's thoughts, but what I thought we could do is I think it would help in some of the motions that the defense has filed is to give me understanding of where we're at as far as the discovery. Have.
Oh God.
Judge,
Unless there's something that's come up since the time of the filings.
Judge, it's our position on behalf of Ms. Gardner, based on the letter sent by Mr. Khalil, that we are at an all stop.
A letter.
Yes, it was enclosed to Ms. Day's motion.
So this is the sound on the court feeds and on or what this is. I have nothing to do with it. But that part's important because he says we're at a full stop. That's defense counsel. We are at a full stop. Strong language.
That she filed,
The one about the reorganization.
and a new drive, that we are at an all stop, Judge. We have made several requests for things that we believe are outstanding. We were supposed to have a deposition
Of
we thought
the detective.
Johns to sort of go over
Why don't hold on? Okay. Let's why don't y'all have a seat? Okay.
Oh boy.
Mr. Khalil, you can be seated. We're gonna settle down. I need to use a microphone.
Please.
What is the state's proposal?
Your Honor, after discussion.
You can use them. Get him a desk microphone. Okay.
Please.
Your Honor, after discussions with counsel and then the state's team, we decided that it would be best that we reorganize. There seemed to have been some confusion as to what exhibits have been tendered, what has been tendered in what format. And so the letter that we sent to counsel was notifying them of our intent to assist the best we can. We are going to index the discovery that has been previously tendered in all of the prior discovery pleadings so that everybody would be working off the same sheet of music. That when we were referring.
Oh my God, he's totally stole Poot's saying. That was a Poot. That's always a Poot saying. You know, Dick Harpootlian from Murdoch, right? He's singing from the same sheet of music. That's really funny.
Referring to a particular exhibit and a file and the file size and everything, that everybody would have the same understanding. That we are in the process of going through and completing that indexing. My proposal, because I've done it in previous cases where we've had voluminous discovery, is to then provide hard drives with the index and all the materials in the format that are discussed in the index to both counsels, and then also file an exhibit with the court. So even the court, when we're arguing motion hearings, would have the same index and have the same materials that would be available for discussions during the course of the motions. It was our understanding after offline and off-record communications with counsel that this would be of assistance to everybody. The other requests that we had made, because Ms. Stifler was getting requests from multiple parties from both defendants' teams, and then also even receiving communications from defense experts about formats that are being received and things of that nature, that we figured it would be better to create an email box. There was an error in the creation of it, but we've now
Oh God.
an email box for communications, and then also points of contact, so that we weren't responding to multiple people on multiple sides, so that we would bring some sense of order the best we could.
It sounds like a lot of excuses right off the bat to me.
This was a suggestion and a proposal that we thought would be the best way to sort of try to bring some organization to it, and we're working towards that effort.
He's doing a lot of talking, right? Like, and let me know if I need to turn myself down even more. Again, they might boost their sound at some point. It sounds like they're getting people microphones, but let me know if I need to turn myself down more. But this is just like it's just like when people are guilty of a crime sometimes, right? Where it's like they get asked a simple question. You know, again, can use Alex Murdaugh as an example. It's like, where did what time did you find Maggie and Paul? And it's like, well, my mom has late stages Alzheimer's and on and on, right? I mean, it's just like, he's just talk. Sounds like a lot of excuses.
To do that. And we felt that after discussions with council, would be beneficial to both teams, to the state and to the court moving forward, so that everybody was a little bit more organized. This is obviously a very discovery intensive case.
Was that the defense proposal? You can be
Yeah,
seated.
no, Your Honor.
Use the microphone.
No, Your Honor. Well, in fact, the first time I heard about it was when Mr. Khalil called me and told me that that's the way that they were moving forward. Because from on Ms. Gardner's position, it was not. We have concerns. We have spent hundreds of hours going through what's been turned over, and we have complained about both the organization of the discovery, the file titling of the discovery, the duplicative disclosures, the vagueness in the discovery exhibits, and now seemingly we are going to have to go through every single thing again to make sure that what the state now proposes is the version we will use for trial is exactly what we've already reviewed. And there is no way for us to do that without opening up each file and confirming things like the page numbers match, that they are the same files. I mean, Judge, we don't know what we don't have, and we've voiced that several times. We've gotten different files that appear to be the same that are not. And I under the law, we have a right to have the discovery, but the manner has been so disorganized with a lack of.
Now, I will say the closed captioning is doing a pretty good job. Thank God for that. So this right now, who's speaking? This is Mr. Karoti for the defense. He's one of Shanna Gardner's defense counsel. Let me know again if you want me to change anything with my volume. But again, I usually have it on auto adjust, but I put it on, like, I took that off so I could turn it way down. But yeah, definitely the closed captions are probably the way to go. Now, I think it gets adjusted throughout. Again, they're seem to trying to get their act together here, but
Of clarity, as was even pointed out at the last status conference, and what they are turning over, that we're frustrated, Judge. Frankly, we're frustrated. I mean, this is going to delay the trial. There's no other way about it. It's going to increase the man hours that our defense teams, which are privately retained, have to expend just to make sure we know what we have. And it's, the word I would use is frustrating, Judge. It's simply frustrating.
And I see Ms. Day. Ms. Day, you are the contact person for Fernandez, correct? And you're the one that's been going through the discovery, correct?
Yes, Your Honor, and I would echo everything Mr. Karoti just said.
Are you using the microphone? For the benefit of Zoom, you have to use a microphone.
I think so.
Okay.
Maybe. The only thing I would add is we've tried this before. Both our firm and Mr. Karoti's firm have previously been provided externals that we were told contained everything that the state had. We have meticulously reviewed the externals, provided list of things that were missing, and then we were told next point was coming, everything would be on next point, and all will be well and good. We got next point, within 2 weeks it was shut down.
So that was the first platform that they used where all that discovery got leaked. That was attorney-client privilege and whatever. And so that was Next Point. So they went from Next Point, then now they're on evidence.com.
Went back to the externals. Once again, we're told everything will be on there. All will be well and good. Just be patient. We get the externals. We do the exact same thing all over again. Then we're told evidence.com will fix everything. Just be patient. We'll upload it. Once again, review thousands of documents. And we're still requesting the same missing discovery that we've been missing since last May.
Mr. Khalil, I know that you are maybe coming in and offering this as a solution.
By the way, so for those of you guys who were there yesterday for the BK live stream, and I talked about how Shanna Gardner had a homemade or jail version makeshift dildo that was confiscated from her jail cell. For anyone who's newer to this case, that's the defendant that Shanna Gardner, she's in the gray sweater. Her estranged husband and co-defendant is in dark green there with the ponytail. That dude, that's Mario. It's her estranged husband. But Shanna is the one there in the gray sweater, and that's the lady, the defendant who had that dildo confiscated from her jail cell. So.
sitting in the same position. I don't think it is. I really just don't think it is.
Oh, yes.
So
That's right, Blackwater. You
I
heard correctly.
have printed off, and
It'd be the type that you can make in jail. I don't know how. I mean, we don't know. We don't know. I would love the details, but somehow she had made one and it was confiscated.
when I printed off
Yep.
all the state's
Jail.
disclosures,
Your jail
okay,
jail materials.
printed off the specific demands. I have tried to just so I could try to get some type of understanding, lining it up, and it just doesn't. And the same thing that the defense is saying has been the same thing that this has been communicated with the court. I believe the parties can correct me if I'm wrong. I tried to conduct a case management hearing, maybe, y'all correct me, like around December-ish, okay, right before kind of holiday break. And I was told something similar, that hard drives would come in, and I don't necessarily think a hard drive will fix this problem, because I think we're on hard drive number 3, we're on cloud service number 2, and y'all can correct me. I think the defense is objecting to evidence.com because something was inadvertently uploaded.
Oh,
Yet again.
yet again. Yet again.
Ms. Gardner's devices were uploaded.
Miss Gardner.
She obtained an unredacted copy of one of Ms. Gardner's cell phones that contains attorney-client privilege.
Listen, guys, to this bullshit, if you will. Mother of fucking God. Hold on.
Defense is objecting to evidence.com because something was inadvertently uploaded. Yet again.
Ms. Gardner's devices were uploaded.
Ms. Day informed me that she obtained an unredacted copy of one of Ms. Gardner's cell phones that contains attorney-client privilege.
A copy of Shanna's cell phone, which including attorney-client privilege. Like, I can't even wrap my head around this. How?
Defense is objecting
Again.
to evidence.com
Again.
because something was inadvertently uploaded. Yet again.
Ms. Gardner's devices were uploaded.
Ms. Day informed me that she obtained an unredacted copy of one of Ms. Gardner's cell phones that contains attorney-client privilege.
It's not going to fix it. So
I don't even know, because this already happened. I mean, oh my God. Oh my God.
To facilitate what did y'all do with the hard drives that have previously been given to you? You're just keeping them?
Happy Annie, you're saying, can I recap like the part about the discuss? Yeah. So I think I just did, but I can say it again. So yeah, because it was quieter there. Okay, hold on.
I think the defense is objecting to evidence.com because something was inadvertently uploaded. Yet again.
Ms. Gardner's devices were uploaded.
Miss Gardner's devices were uploaded. Okay, they're talking about evidence.com.
Ms. Day informed me that she obtained an unredacted copy of one of Ms. Gardner's
Miss Day informed me that she obtained an unredacted copy of one of Miss Gardner's
cell phones that contains attorney-client privilege.
cell phones that contains attorney-client privilege. An unredacted copy of one of her cell phones, and it contains an attorney-client privilege. I just can't even.
It's not going to fix it. So
It's all good. It's all good. Can you hear me okay? Because again, I turned my volume way down. Let me know if my volume's too loud, too quiet, or anything.
to facilitate what did y'all do with the hard drives that have previously been given to you? You're just keeping them, and you're comparing the two?
Judge, it is so voluminous that most of the stuff we have gotten onto our own cloud service, but that's no more than a file share service. That is at least what Ms. Gardner has done.
Okay, I'm gonna do this. I'm gonna translate again here. Okay.
Judge, it is so voluminous that most of the stuff we have gotten onto our own cloud service, but that's no more than a file share service. That is at least what Ms. Gardner has done, so that we can share it amongst.
I can barely hear that. He's saying it sounds like they're saying most of the discovery that they've gotten through their cloud share service, which is the evidence.com.
So So you're taking the hard drive that the state has given you and you're uploading it to your own file share service. But so you have now two separate kind of electronic.
We have hard drives and then we have working copies, I would say, on the cloud that people can access.
Okay. And forgive me, y'all have to be patient with me because I don't know / I'm trying to get some type of understanding. Okay. So on the hard drive, and I'm gleaning this from a complete like overview of like what y'all are bringing to the court's attention through motion, and also I'm trying to get an understanding from the state's disclosure. All right. So when you all get the hard drives, how does it correspond to what is in writing by the state?
So, and Ms. Day may be better situated to answer.
Well, I'll let her.
Yeah, but
I'll let her take the lead because she's. Let Ms. Day.
yes.
Your Honor, the short answer is it doesn't.
At all?
No. And I have my external, and I'm happy to provide it for the court's review if the court would like.
Which one?
I have our firm's external, but I have a folder on the external in which I've saved everyevidence.com as it was received.
Okay, so let's start with the first one. Okay.
And when you say first one, Judge?
The first disclosure, there's one that was filed on November 15th, 2023. It has both defendants. This is when the joint indictment at or around that time. So if y'all pull it up, November 15th.
Happy Annie, were you saying yes, I'm too loud, or yes, I'm too quiet?
On that particular exhibit, I counted 85 witnesses, category A. Then it is referenced like the different subparagraphs, right? And then there is a Brady disclosure on that particular document. And to my knowledge, while it was written by Mr. Tassoni that the 6th supplement had Brady information in it, but it was not disclosed.
Gotcha. Thank you. Thank you. Thank you.
The 6th supplement. It was just the notes. Are you with me? The notes from Mr. Chipperfield, but it was not disclosed under a Brady paragraph. But the defense.
That was just the transcript, Judge. The notes came. I may be confused 5th or 6th, but the first disclosure regarding tenant was just.
No. I'm on the 6th.
He says, I may be confused, but the first disclosure regarding tenant, and then she says, no, I'm on the 2nd.
Where they give over
Oh, yes.
Chipperfield's.
I understand. Yes, Judge.
Okay, but it was.
And those are the disclosures we just read about in those the previous filings there that discussed Henry Tennant and Mr. Chipperfield, and the disclosures they're referencing those same documents.
Not identified as Brady.
Yeah. Yes, Judge.
It was just notes.
Yes, Judge.
But what I'm referring to is the writing by Mr. Tassoni, who indicates the defense position is it should have been or is Brady.
Yes, Your Honor.
Right? But there's only, what I'm asking, okay, is there's only one Brady disclosure that I'm able to see from the state of Florida, and it is contained within November 15th. Right?
Yes, Judge.
So that's interesting. She's taking a note here that so far there's only been one Brady disclosure from the state, and it was on November 15th. You know why that matters, right? I'm sure y'all know. Interesting. Wow.
I'm still on November 15th.
Or I guess one Brady disclosure, at least as it pertains to Mr. Tennant, it sounds like.
Paring back. There is a writing by Mr. Tassoni that there was a reference to Tennant's jail calls in this November 15th disclosure, but I could not find it. It is the subject of Mr. Fernandez's specific discovery request. Where is it in the state's disclosure that they had Tennant's jail calls?
If I remember the disclosures correctly, I don't believe the state's discovery exhibit specifically identified any defendant's jail calls individually. I think it was just listed as jail calls.
Where? Pull it up, Ms. Day. Or the state can pull it up. Because that's one of the things that y'all wrote that you've been asked.
What happened there is that's the court audio. They just got their microphones working or something. So that was the same lady speaking. I thought maybe it was one on Zoom, but no, that's Miss Day who's sitting there in court, and then that's Judge Kite. Now they've just made it louder. Sorry, guys, not anything I can do about it.
For essentially since the beginning.
And Your Honor, which pleading?
Oh my God. How are they
So
this
Your
bad
Honor,
at this?
we just received the pleading, and we would request time to respond in writing. I think that would assist in clarifying this. We're not prepared to address all the issues in that motion today.
Okay,
Oh my God.
I will set aside a different time today. I don't necessarily have to hear the motions for sanctions today. I can set aside that time. Today, I want to get a full understanding of what just is
Wow.
before y'all start coming up with solutions. And Mr. Khalil, what I'm trying to explain is that this court feels as though if I don't, and then the state then proposes another solution, okay, this is how this case has been going, okay,
Mhm.
which there have been issues brought to this court's attention. I have a relatively short pretrial where everyone says we have a solution. Then I pass this case off weeks and weeks and weeks, okay, for y'all to get together, for y'all to talk, for y'all to do this. And then what comes of that is more motions, more misunderstandings, more violations of the court's orders, okay? And so my thought is,
Hmm.
it may be like, I don't mean to be as methodical, but I've never sat down with y'all. I've never really done this on the record. Every time I ask questions, and I'll give you an example, Ms. Day, if you recall, we were at sidebar, and I thought, I believe it was at the last court date, the state thought that the defense had a searchable a device from the Secret Service. Apparently, the state has the ability, with whatever format they have, that they can search, the defense can't. And then you explained to me that what you all were given is if you click on a document, it's a zip file. It takes X amount of time to unzip it. You wait 3 minutes, you wait 20 minutes, you wait 2 hours for it to unzip. And then when you get it, it's some random search on the internet that has nothing to do with anything. It's a waste of time.
Wow.
It takes us days to download and
Ugh.
unzip the files, and
God.
sometimes we open them and it just appears to be computer coding.
Oh my God. Oh my God.
That's what's going on.
Can you fucking imagine, guys? At least we could hear that part. They get this shit from the state, right? And they have to unzip it, and it takes days. And then when they get it, it's just a bunch of gobbledygook. You've got to be kidding me. Oh my.
So the state thinks that you're giving something usable, and it's not usable.
This is
You
sad.
take issue with that, Ms. Stifler?
Sad.
I
Depressing.
think some of the issues Ms. Day has brought to my attention at least have been somewhat user error. So
Okay. So who's speaking right now, guys? Right? Oh my God is right. Happy Annie. Who's speaking right now? This is ADA Stifler. Okay. And listen to this bullshit. This is crazy. This is a death penalty case for both of those defendants. Oh my God.
You take issue with that, Ms. Stifler?
I think some of the issues Ms. Day has brought to my attention at least have been somewhat user error. So some of
No,
the requests that
not
I've
Use the
good.
microphone.
some of these requests I've gotten in her most recent, or the letter that I've responded. They have sent me lists via email. I have responded via email, and in the state's first supplemental demand, in an italicized portion of that demand, I responded to their list. Some of the issues she's raised to me, we've discussed at a discovery conference at our office. Some of the platforms of the information for downloads through Axon or Axiom for the computers are HTML based. So if she opens it, the report goes through a web browser. That's just how it works.
Here's what I have to say. I don't give a shit. I don't give a shit. It is their job, the state's job, to make sure the defense can access the discovery. Done. Fix it. Solve it. This is crazy. This has been going on since the very first, since day one. Same type of thing. They can't access it, and when they finally get shit uploaded, they're disseminating attorney-client privilege information. By they, I mean the state. I don't even know. I don't even like. You know, again, it's just like some of these other cases. It's either gross ineptitude, right? She said user error. It's like either extreme ineptitude or it's willful and intentional.
That's one clarification I wanted to make.
No.
As far as the extractions we've provided to defense counsel, our UFDR
It's
files.
just more excuses. Just like with the dude from the beginning who was hard to hear, for the other dude from the state who we haven't heard much from. Why are they making excuses? They should be like, look, we will do whatever we can to make this right. Like, why are you making excuses? I don't understand. I mean, I guess the reason they're making excuses is because there's a motion for sanctions on the table and they don't want to get in trouble. But they should be groveling. Seriously.
Which they can open through Cellbrite. They also requested the raw data, which I made available to Ms. Day to go to Secret Service and get the raw data for her client. For Bias Firm, their expert has been contacting me directly, requesting new copies, first original copies, various formats of different data, and I've
She's
complied
not
with
even
the
answering
subpoena
the
to give him
question.
what he needs.
She's not
We
even
have
answering the question.
our expert,
Oh my God.
who is referenced in the letter Mr. Khalil sent, who's going to coordinate with Bias Firm expert, and if Dreiser Hill has an expert as well, to get them the digital data in the formats that they're requesting. So part of it is they're asking me, they're using terms with me like raw data, and I'm giving them what I believe they're asking for. My expert is gathering all these things in one place on all the devices to give it to them in whatever format that they're actually requiring. So they have both the readable version through Cellbrite and the raw data itself. I don't know which one she's looking at. It sounds like she's looking at the raw data.
Oh my God.
But we've provided multiple versions in different formats for these things several times.
When you say raw data, you mean like metadata behind whatever might be, not metadata?
Not metadata.
Okay.
So when you when you do a forensic extraction on a cellular device or
Oh boy.
computer, you're copying the information on the phone and decrypting it. You have to parse that data through a software program. For example, a phone, you would use Cellbrite. For a computer information system, in a car, you would use Ivy. You would use Axiom for a computer. So when we provide that to them, we give them the reader. We would give them Cellbrite on the phone extraction so that they can pull the parsed data through Cellbrite, open it, and read it the way you would a regular phone download.
Why is
Their
Snapchat
experts
taking it
in
out?
their
Like what?
firms have also requested the raw data. I presume, and I don't know, that their expert perhaps has some sort of forensic equipment or a physical analyzer that they want to parse the data themselves and make sure it matches up to what we've parsed. So the example that we've been given from Cellbrite is you have flour, eggs, sugar, you have cake batter, and you have a cake.
Oh
We've
my
provided
God.
them the cake, which is the finalized PDF reports. We've provided them the cake batter, which is the UFDR file, so you can run through Cellbrite. And we provided them the ingredients, which is the raw data.
All right. How are you?
I'm going to respectfully disagree with Ms. Stifler.
Wow.
And I also want to point out for the court that our digital forensics expert had a flight down here on February 25th. He had confirmed the date with Ms. Stifler by email on February 10th. I have the email if the court wants to see it. Ms. Stifler indicated that she would be in trial, but someone from the state can be present. I will have Detective Ostertag reach out to Mr. Green directly, our forensics expert.
Mr. Green. Okay, couple things. So first of all, overlap with Carrie Reed, multiple. Mr. Green. We don't know which Mr. Green. Could be the same Mr. Green, could be different Mr. Green. But also, isn't this so reminiscent of the expert that went to get the lollipop footage and they fly out there and then it's like, oh, sorry, we don't have it, and all that. Sounds like they're being given the runaround after they pay to have an expert come out, right? And in this case, it's a Mr. Green and it's a forensic expert. It's for the defense.
Detective Ostertag never reached out. Mr. Green was prepared, and it was canceled because the state was unprepared for the meeting on February 25th that they agreed to. So, I mean, this is, and our expert has looked at what Ms. Stifler has provided via evidence.com and said, that is not what we're asking for. And so the solution was that at our expense, right, we were going to fly our expert in to meet with the state, to literally look at it in person, perform whatever methods he needed to perform, and the state canceled. So I mean, I think this idea that they're doing everything they can and making sure we get everything we've asked for is not true.
Okay.
The meeting did not happen. I did not cancel it. Mr. Green canceled it because he said he had not heard from Detective Ostertag. I reached out to Detective Ostertag and Detective Johns to reach out to Mr. Green, but Mr. Green said he was just going to go ahead and cancel.
That was the day before, Judge, because no one had reached out to him. He wasn't going to get on a plane without being confirmed that he was going to have a fruitful visit here. No one had reached out to Mr. Green after the meeting was confirmed on February 10th. And I've got an email from Mr. Green, bringing this to the state's attention on February 24th that no one has reached out.
It's not frozen, guys.
So the defense is saying that whatever has been provided, you cannot use it for your defense preparation.
I've not looked at it specifically, Judge, because that's why we have an expert, but our expert has told us that is not what we want.
Okay.
And Your Honor, I would just add, while we have received several copies of certain devices, oftentimes the file sizes are completely different. So we have no idea if there was a download error, if there are different versions of reports or downloads. We have no confidence that the versions we have are full and complete. We're just wasting our time reviewing incomplete documents that we're going to have to completely redo.
And you're talking about from the point in time that I'm at, which is November 15, 2023. You have no confidence that these things are complete.
For instance, Mr. Tennant has several cell phones. One of them I've gotten 4 or 5 copies of, and all the reports are different sizes. Ms. Jensen's cell phone, I've also gotten 5 different versions of. All of those reports are different sizes. So, and these reports, they're 100 gigabyte reports, they're massive. So to spend time reviewing all of them.
What is the explanation of that?
Because we provided them via evidence.com, our next point. If they're down, again, it could be on the user end. If they're downloading it and their computer's running another task, there could be skipping in the data as they download it or an interruption in the download. So I have my forensic expert. He's going to go to the original extractions, rehash all the values, provide the hash values, which is the file size for each original download that's in the possession of the custodian, the original devices, and provide that to defense. We met with him yesterday to get that completed. And just for the court's information, the indexing that we're describing, I have listed these items and provided them. It is not intentional on the part of the state. It is, obviously there's voluminous discovery. I've been attempting to provide them what they're missing. There's difficulty with them receiving things through cloud-based downloads or for transferring. And Ms. Day, and I'm not faulting anybody, but we have sat together multiple times and transferred things from her laptop to my laptop. Neither one of us can control the computer processing and perfection of the download.
I understand. I'm not having any hearing on sanctions. What I'm trying to get to is, so the state is proposing something, right?
Yes,
that you
and
re-index.
I'm going to clarify one thing that Mr. Khalil said. The thought process behind the index and for defense counsel's information as well. And I spoke with Ms. Day about this. I'm not intending to re-provide them all this discovery and say start from scratch. The idea behind the indexing would be that I provide them a number for each exhibit, which would be our working number for trial for our exhibit list, so that that number stays consistent throughout the entirety of litigation up and through trial. So we're all clear what we're talking about. That number corresponds to the name and a sufficient description of that piece of evidence, and that we tag it where it is on evidence.com, what file name it's under, where they can find it, and where it's been previously disclosed in the state's supplementals and original discovery exhibit. So I just want the court to kind of understand the thought process behind the state. It's not giving them a whole new hard drive and indexing it. It's an index of what we've already provided, hopefully to be a roadmap that they can look at. Exhibit 643 is Henry Tennant's phone. It was listed in State's Exhibit 1 on page 4. It has been provided on evidence.com under subfolder subpoena search warrant returns, titled as this, audit trail showing it was downloaded by defense on this date.
Can I stop you for just a moment?
Yes, ma'am.
So in listening to what they're saying, because the state has provided multiple copies of potentially the same thing, and they're, I guess, concerned that whatever they have is not what the state has / what the state would use, how would that then solve the problem? Additionally, how would that, because from what you all have been telling me, okay, what I'm understanding is that the state has not tagged every single file / thing that they have gotten, and you've been kind of doing it via email or whatever. And then how would you document a second, fast forward, 5th version of whatever they have?
So the evidence.com has an audit trail, which is, and obviously I've sent some things via the portal, which has an electronic trail of what they received. The responses to their emails and letters have been by email, which I asked Ms. Day.
I mean, evidence.com though, right?
The letter she attached to her filing, or Mr. Tassone's filing.
I know, right?
the letter
I'm with
about
you on that.
discovery. I asked her to number it so that I can reply via letter in numerical sequence as well, saying
It's a mess.
Say number 1 was the HTML issue. I can't get this computer to open it, tries to open a web browser every time I click on it. I would respond, 1, Axiom is a web-based application. It will open a file through a web browser. Item 2, we are missing X subpoena. The subpoena is in the Jacks Beach Police Department Supplemental Report 5 attached. So that's how I was planning on responding to her letter. The indexing, the way that we've organized the discovery on evidence.com is in subfolders. So it's organized under a tag of subpoena. It will have a subpoena and the subpoena return.
Judge, we've never seen that. It comes in similar to the screenshot that Ms. A attached, where it's just files with a series of numbers. And
Hold on, let me Let me get there, okay?
Yes, Judge. Like page 16 of 109 in Ms. Day's motion.
And that's what Mr. Dreiser attached about that transcript.
Yes, Judge. They're unlabeled. They're just numbers.
Is that not how it looks for the state?
It's not how it looks for me, but I cannot change the file names of these documents. Some of
Right,
these
but-
the electronic documents, because that would be changing
Hold
the
on,
original name of the
pause for
file.
just one moment. So this screenshot, and I'm looking at 16, Exhibit C, okay? Now I'm looking at 16 and 17. So let's start at 16. It has a series of file folders, right? And then it has a bunch of like various file types and MP4, which I'm assuming is some type of audio, and then a bunch of PDFs.
Yep. And if we want to know what that is, right, we have to open it, determine what it is.
And sometimes the opening, that's what you're saying. Is it a zip or unzip? Like,
We download it as a zip. We have to extract it. When we extract it, this is what it looks like. And then, for example, if I want to know what 2024-1031-103_104-282-212_7, I have to open that. I determine what it is. I then have to do a save as, create, if I want to remember, like if I want to find this at a later date, right? I have to do a save as, save a duplicate copy in my own files that this is the transcript of the January 13th 10 in court.
okay.
Because there's no way for me to correlate this to what the state is turning over unless I open it up, review it, and save it under a different name.
Okay, pause. Now, so let's say, Ms. Stifler, look at page 16. On page 16, how does that look to the state of Florida on your end of evidence.com?
The files are categorized in subfiles: subpoena, search warrant,
So
interviews.
they don't have these numbers.
I'm not sure. It's the same way on the CIP when we send discovery. Through
I
the
don't know what
portal.
CIP means.
It's the portal that we use in most cases through the clerk's office. So
Okay.
they sign up for e-service. We go through. I have no control over how the specific programming titles things when they're sending them.
Okay, go back.
Yes, ma'am.
Is that how it looks to you? Yes or no?
No, ma'am.
Okay. Is there a way for evidence.com
You gotta
for the state?
So Judge Kite is in a really tough position here because she's got to try to figure out all this, and it's a mess. And the thing is y'all probably know there's like a whole thing, right? It's one of those true sort of stereotypes, if you will, or whatever, of like lawyers and technology just don't mix, right? And so this is like the blind leading the blind in a way, but the thing is that in every other case they figure it out. I'm like, why the hell is this? You know what I mean? That's really the thing. Like this prosecutor's office is their job. It is their job to turn over the discovery. And like everyone else seems to manage. Like I've never seen this many issues with like the digital evidence or the digital discovery and the platforms having a problem. And like, you know what I mean? Like, can't they just like ask how it's done over in Leon County, for example, or Orange County? Like, why can't they get it together? Right. I mean, for real, there's a way. Ask the YSL. No fucking kidding. Yeah, absolutely. There's this case certainly does not have the largest amount of digital discovery of the all time. No way. Yeah. Oh yeah. Yep. Also happy to see you again, official. Yeah, so this is Mario Fernandez Saldana, for anyone who's not as familiar. So this is Shanna's estranged husband. So for anyone who's here, I think you were here officially yesterday. So Shanna Gardner, right? You remember us talking about the dildo that was confiscated? So she's here, she's in front of him, right? But that's her estranged husband. But this is that same defendant we talked about. So
To give the defense what you are looking at, because what y'all solution is not a solution if then you create some index when you're viewing it from the way that you can see it and then giving it to them, and then when they look at an index, then it's just a bunch of numbers and then they're back in the same situation. Do you see what I'm saying? Like if you're not, it's not comparing apples to apples.
And Your Honor, if I may add, I think that was the purpose of the hard drive and the cross-reference index, is understanding, and again, I'm probably not the best person to be talking about digital evidence. I'm a dinosaur. I'm a paper guy. But when
Oh,
we are
God.
talking about this digital evidence, it is being transferred not at the fault of the state, but as a fault of the delivery mechanism in a different view.
Understood.
And so that was our goal in having it in the hard drive, so that everybody, when they opened, hypothetically, index number one, where it's all labeled index number one is what we're looking at. So there's not a difference based upon what my evidence.com screen shows and what their evidence.com screen shows. When we open
Let
up
me just
one,
say, like, it's called evidence.com. I mean, this is like, it's funny if it wasn't such a mess, right? Because it's like, really, like, let's start there. Anything called evidence.com, like, it sounds like one of the first websites ever created back in the history of the internet, when like the first 20 websites or whatever, you know, the domain names were taken, like evidence.com. I mean, no, like he said, dinosaurs, right? Like, I think the dinosaurs used evidence.com for their evidence, right? And they had better success than this prosecution team did.
when we're all looking at the same document. And we're going to say, when we're looking at that, this is where it was previously tendered under this supplemental discovery response. And this is the data size, how much data, what the size of the file was when it was tendered. And that's the size of the file that it is.
What I'm saying is, I don't think that you're hearing them. So y'all could do that on your.
Okay, so this is great. This is where Judge Kite starts to let them have it. And I will say, this courthouse is gorgeous. If you guys look at the thumbnail, the background of the thumbnail is the exterior of this courthouse. This interior is gorgeous. It is beautiful. I love it. And so now Judge Kite's gonna let them have it. Woo!
Data size, how much data, what the size of the file was when it was tendered, and that's the size of the file that it is.
What I'm saying is, I don't think that you're hearing them. So y'all could do that on your end.
And it reminds me, she's like a therapist right now, right? Like Merritt, think about couples counseling. Like, that's literally what I think of when I hear, I don't think that you're hearing them. It's just, it just is so reminiscent of that to me. If you guys can see that, right? Like, they're fighting. I mean, it's worse than that, obviously, but like the way that she's saying that is like, you're not hearing them. I mean, accurate.
Does not correspond to what they have been able to see. So you all could go down a line and say, this is on, and you all could say, this is subfolder this, it is referenced in state's exhibit, filed on such and such date / such and such date. What they are saying, and what y'all are failing to realize, is that they have multiple versions of these things. And so they have been saving them as file XYZ. And so if y'all do that with a new index, with a new hard drive, then that is what they are saying that they have to start all over with, because the mechanism that you all have been using has somehow undone, or whatever y'all are looking at just comes in a bunch of numbers / whatever. And so there's no way for y'all, this index, to truly cross-reference for them to make it easier for them.
I'm going to have to speak to Jack's speech about that. Presumably I could get, and with a next point, originally the idea was it was labeled individually and they couldn't bulk download. They had to download things through subfolders. This gave them the bulk download option, because I was told they need a bulk download option.
But then it comes in numbers.
Yes.
I understand, Judge. My point being, I'm not being difficult. I'm trying to adjust to what they're asking for.
Oh my God. This is 80 Stifler speaking. The excuses, instead of the solutions, it's always excuses. I just can't.
And to provide it in multiple ways.
Y'all, look, we're going to just,
Judge.
I want y'all to just strike all this. Like, I'm not doing this intentionally.
Thank you.
That is not the purpose of this hearing. Okay.
A solution that I might propose.
She cut.
I have to put a pin in.
Look, she just interrupted the judge, dude.
This involves giving them access and accounts to evidence.com, which Jacksonville Beach Police uses as their case management system. It would be like us giving them a login to Stack. There's like security clearances, there's issues with that. But if there is a way for me to dupe my evidence.com folder into one and remove access to Jacksonville Beach Police case management system for their entire police department.
Who manages this system? Is Jack's Beach, or like whatever this web service is?
Evidence.com is how we receive evidence from some law enforcement agencies. They use it as their case
She's not
management.
answering the question. I want to remind you guys what the question was. Who manages it? Okay. Who manages this system?
System. Is Jack's Beach, or like whatever this web service is?
Evidence.com is how we receive evidence from some law enforcement agencies. They use it as their case management system. I have an account to access this particular case file.
She does this with literally every question the judge asks her. She never, ever, ever answers it. It is crazy. I wish Judge Kite would be like, stop and answer my question. I'm sure at some point it will happen.
And to share files with defense counsel. I don't have authority to share access to evidence.com with them because it's the Jacksonville Beach Police internal system.
I'm not suggesting that.
My suggestion is perhaps there's some way I can do this by creating a mirror of their files on my account and sharing it with them with limited access so they can't get into Jacksonville Beach Police case management system. Not that I think they would, but obviously they're.
And Judge, if I may just add this one point, and again, using the paper analogy,
Oh dear.
this is not foreign. If this was a paper case, hypothetically, and we tendered 1,000 documents and we in discovery, which has been done beforehand, how I label my trial file is not going to mirror how Mr. Carodi labels his trial file. I'm going to label my evidence folders or my witness folders or my evidence in the way I organize, because that's what I do. Even prosecutors across the board don't use the same organizational system.
That's not the problem.
We are providing
That's not the problem.
the discovery. What's
Oh my
difficult
God.
is
Yeah.
I don't know how we get everybody to organize their trial files in the same way, and I think that's what everybody's trying to do here.
No,
That's not it.
Literally what I just was saying. That's not it. I love that. Dude, every single one of these prosecutors, though, this is crazy, right? This is crazy. He's like trying to say it's just an organizational thing. No. Oh.
Difficult is I don't know how we get everybody to organize their trial files in the same way, and I think that's what everybody's trying to do here.
No, that's not it. So
thank you, Judge Kite.
From one dinosaur to another, okay? When you have a paper discovery, if you gave it over, you would say property card, sequence number X with 5 pages. So then when you gave that exhibit over, there is no chance of change. So therefore, you, through the state, to me, this paper is the only thing that really matters. Y'all's emails back and forth, you're this and that, and you say, well, Miss Day, that doesn't mean anything. This is the only thing that means anything. And so then, like, for example, if I go, I'm still on this first one, right? Like if I go to the physical evidence, this should never change value. So the paper is different. So if you documented, I gave over this document with this many pages and identify it, then it doesn't matter. I don't think that they're asking for a same trial file. What they are asking for, and that what this court should ensure, because these cases must stand the test of time. It has to be able to be, and I will tell you, like it is a concern. Like the different platforms have to be consistent for now and future review.
Yes.
Okay. So this is kind of where I'm at. I don't necessarily think, from what I'm hearing from both sides, that you have to start totally from scratch from either side. What I think needs to happen, and where the state, because we're too far in, right? I think what needs to happen is the defense needs to identify the problematic electronic evidence, and that's where I see the majority of the problems coming. The electronic evidence of the multiple versions, okay? And I don't know, the hard drives that you all have gotten where you have the problematic electronic evidence, where it's the multiple downloads. What I would ask is that the defense identify those problem downloads, okay? The problem electronic evidence. That is where we're going to focus, okay? In indexing. Okay, we're not starting from scratch because we're too far along. Then when you all see the problems, and maybe does it have any potential of having like attorney-client privilege, or are you just giving back what they've given you? Or is there a way for you to duplicate how you are seeing it? Do you understand what I'm saying or asking? Okay, so let's say, I don't know what this is because it's just a bunch of numbers. It's Defense Exhibit C, whatever this is, okay? Could the defense somehow duplicate that for the state, give it back? Does that make sense? Like, so y'all have identified, I don't know what this is, these files, okay? Duplicate it. Say, this is what we want indexed. Is this, what is that? Who is that? This is what we want indexed, okay? And then the state, you go through and index that and give them back what you are going to use in an index form, what you all are proposing. Does that make sense?
It does, Your Honor.
So y'all are not just going through and saying, we're going to redo everything. It is what they are having problems with. So if they have basically, and if y'all have different values of electronic evidence that you all, maybe it's not on this evidence.com, but you all give them back a hard drive with whatever this is. If y'all have to buy 900 hard drives for each individual thing with an index on it that everyone is working off of, and this is what you're going to use, then minus whatever evidentiary redactions may be needed in the future, but you're giving them exactly what you're going to use, not a download, not a user error, but something that they can plug into a computer and say, this, we can count on that as being what the state is intending to use.
Yes, ma'am. That was the thought process behind this. I told them whatever we indexed or tagged, that would remain the identification number for our exhibit list. That would be what we're using at trial. We're not going to use a different version. That process has begun.
Do you know what their problems are?
Somewhat. I think I have Detective Padilla who is cross-sworn with the Jacksonville Sheriff's Office and the Secret Service. I've given him a chart where I have put in one chart all of the devices where the extractions are housed. He's going to the original data. He's going to pull an original copy of raw data and UFDR for all the devices minus their clients. He's going to make a chart with the hash value, file size, and confirm the data is complete and perfected, and provide that list to me and to defense.
No. They need to identify, you can do that
Judge
on your
Kite.
own, but like they need to identify where their problems are. And so instead of you doing all of that, you wait for them to say, these are what we have been working on / concerned about. And then you all give back exactly what you're going to use related to those particular devices.
Yes, ma'am. And Ms. Day's provided me a list. I'm working on that. But I only say that for the court to understand that Detective Padilla will be able to give us the confirmed hash value of all these devices. So they can let me know what hash values they have. They can tell me they're missing a download, but if I have to compare it to this list to see if there actually is a problem or if that's the actual file size.
So, by the way, so there's the defendant on the left there in the gray sweater, if you can see my mouse. So gray sweater, curly hair, that's the defendant, the one who had her dildo confiscated.
That's in process on the state side. Whatever they give me, I'm happy to cross-reference and re-provide. Ms. Day has already given me a list that we've been working on. I did a partial response on state's supplemental discovery 1 to one of her lists. And I told her to, if she numerically listed it, that I would respond numerically as well. And we can file those with the court as a request for discovery and discovery response.
Okay. So that I am, because I mean, I'm not privy, nor do I want to be privy to any of y'all's emails. If the defense would identify through either motion to compel or motion, some type of discovery motion, what you are duplicating / giving to the state as far as problematic. And when I say,
so we don't know if the dildo was rock hard, but the rock hard part has not happened yet in this trial. That's not in reference to the dildo, but the judge does say there's all kinds of that's what she says. We haven't gotten to them yet, but also, yeah. So separate but equal, if that makes sense. So yes, so Shanna Gardner did have her makeshift dildo confiscated. That's a great point, though. Her own Happy Annie says my only issue with this is that it creates work for the defense right off the bat. Yes. And that's the other thing too, because even if they continue the trial date, right, then you're still dealing with, again, it's still prejudice to the defense because they're having to pay for private counsel. And Jose Baez, I'm sure, is not cheap, and he's worth every penny, but still. Yes, Spicy Rock. Yeah, that we still have to follow up on our historic sex toys live stream conversation from yesterday. But yes. And she actually says as problematic. And when I say, let me back it up so we can get the beginning of this context here.
Would identify through either motion to compel or motion, some type of discovery motion, what you are duplicating / giving to the state as far as problematic. And when I say identify, I mean, let's say I'm just going to hypothetically, it is, I don't know, Henry Tennant's cell phone, like you said earlier, Henry Tennant's cell phone, version 1, 2, 3, however many you've gotten, right? And then you say motion, and then date tendered, then motion to compel Henry Tennant's actual download for what you, that is what you intend to use. It sounds to me that this evidence.com is not a usable / workable format. So I'm not sure. I understand it might be their operating system for like a law enforcement aspect, but for court purposes, it is creating too many problems.
And the benefit to it, Your Honor, just so you understand why we did it, is for the very reason that rather
it doesn't matter. Stop.
plugging their hard drive or flash drive into my computer and transferring something and giving it to them because I am operating off of. That's the evidence that Jacksonville Beach Police has in their possession, that I have in my possession. They have access to download it. We ensure that we all are looking at the same evidence.
But you're not. You're not. And that's what's creating the problem. And it might be usable for you and law enforcement. It is not usable for the defense. They have been saying now, I think for about 13 months, that they are getting this, and that is not usable. And also for court purposes, for record purposes, it is not corresponding to what I couldn't make heads or tails of this, to be honest with you. Like, this list is wonderful that is on the back of this exhibit listing all the evidence, right? But it doesn't correspond to anything. So, and I understand that you all want to index, which I think is great. Okay. If you all were working along the same lines and you could say on state's exhibit, whatever, this and this, but they are looking at numbers. And unless you know what numbers they have, there is no way for you to properly index it for review where everyone is working off of the same thing. That is what I'm trying to explain. So what I want, and by the next court date, I want the defense to identify the problematic, electronic files and how many versions you all have, to the extent, and you let me know if this is a problem, but because I'm working in an unfamiliar area, right? So if there is a problem with you all duplicating what they gave you, not anything that y'all, like your work product, right? But what they gave you, you could duplicate it back to them. And then once the state has the problematic evidence,
Oh, here comes some
then
people. Wow.
I'm going to meet with you all, and you can give it to, I'll give you some time. You give it to the expert, and I need to know from whatever law enforcement or whoever, whatever, is able to review it. And I want to know how it is going to be communicated back to them. The way that it is communicated back to them, that is disclosed back to them on black and white paper, will be what it is going to be, So that would ensure, hopefully, that what the state is saying is going to be what will be in this case, period, end of story. Not some cloud manipulated user error download. And I want to know like how big it is or whatever. And if
That's
you need
what
to
she bring these
said.
people
In, explain to me how it can be disclosed to them in a way that we can all be confident from this day to the last day that it will remain the same.
I love those.
That's what we're going to do.
I love those fancy gates. Those are so cool.
I understand, Your Honor. And looking at this is the first time Exhibit C, I'm seeing what they're
I have no idea.
I know, but they have been saying the same thing.
Well, and Judge, I think one way we can do this, and we'll work towards this effort once we receive the problematic list, that's adding another column to our spreadsheet of our index. So we're going to have all that, and then we're going to have their identifying factor corresponding with what our corresponding.
That's the state.
Okay.
That's
So,
really,
I mean, when y'all are looking at these numbers, do y'all have it cross-reference, or are you just doing what Mr. Carodi said and just changing it to whatever y'all remember it to be?
Change it, but also, as we said many times this morning, because
I can't hear you, Miss Day.
Because we have received so many duplicates, and not just true duplicates,
That's gotta
but
be so frustrating.
partial and
reorganized
reorganized and relabeled. It's not just necessarily we download this from evidence.com. I identify this as report supplement 152 and label it as such. I then have to go back through what we have already saved, download, and reorganized to see if it's something that I've already received.
Yeah.
Let me ask this, for the defense. Let's say y'all identify the problematic electronic files, and then when I say duplicate, meaning that y'all duplicate it for the state.
That's also an additional problem. Like what she just said. So she's like, they're getting stuff that's duplicates, but it's not even duplicates of the same thing, which would be bad enough. It's duplicates, but they're different versions. So then she's like, well, I have to go and figure out if it's part of the same thing or whatever. But it's like, to me, it's like, well, hang on. There's another issue there, because why are there different versions of the same thing that the state has? Like the the state is turning over different versions of the same thing. Why are there different versions? Shouldn't there just be one? I mean, that's concerning.
Y'all have already gone through these things, correct? Okay.
Well, not that we've gone through in the sense that we have downloaded and logged that we received it, and potentially whether or not there was an issue in opening it. By no means is the defense saying that we've fully reviewed every Google return or cell phone download. That is certainly not true.
Okay. I'm asking, okay, for record purposes. So if you all download, or I'm sorry, you all duplicate the problematic electronic evidence, right? Then you send it to the state. You file with the court under seal, okay, for later review if needed, okay? And that seal will mean that those versions, 1, 2, 3, 4, 5, however many they are, I would enter an order excluding them. Excluded. So then with the state, you all have the problematic files. You simplify it into the file that will be used. Okay, so whatever gets communicated back, they can count on that that is what you are going to use. Okay, not version 1, 2, 3, 4, 5, but this version that you will amend your disclosure back to them. Okay, that will be what it will be. Okay, forevermore.
So that's the second time she said that. And I thought it in my head the first time. By the way, there's more people coming in, but I'm just thinking like, que sera, sera, whatever will be, will be. You guys know that song?
Ones that you all duplicate and file with the court under seal will be excluded from evidence. So that everyone will be working off just whatever you provide this final time. Does that make sense? So then it's not any cross-reference. What my thought process is, okay, is if they give you back what you gave them in these number forms, you can give it to whoever is reviewing this and he can confirm, maybe it is user error, maybe it is some type of interruption, but he can say that, okay, I'm compared these, not them, not their time/expense. Your expert, he compares all this and he says, this is the actual version and give it back to them. Does that make sense?
It does, Your Honor. And
Okay, so
we are sort of undertaking that already.
you're not, I know, but like
No.
y'all have been telling me this month after month, day after day. And
her response is me. Like, listen, like she's like, we're already doing it. No, ma'am. No, ma'am.
Is the interruption, but he can say that, okay, I'm compared these, not them, not their time/expense. Your expert, he compares all this and he says, this is the actual version and give it back to them. Does that make sense?
It does, Your Honor. And
Okay, so
we are sort of undertaking that already.
No.
You're not, I know, but like y'all have been telling me this month after month, day after day. And what is occurring is the state is doing this, but it's not being communicated in a way that anyone can be confident that it is the evidence that will be potentially presented. So their investigative purposes. So from that sense, the problematic electronic evidence will be excluded. Whatever y'all identify, it will be communicated back to the state of Florida. Okay, and then what you amend/disclose to them at this point in time is it. Okay, that's it. And then so like I said earlier with that next point, evidence.com is not workable. Okay, so you all have to find some way.
No more evidence.com.
Evidence should not be able to be manipulated. It should not be able to be like you see one thing, they see another. Evidence has to be reliable from all standpoints. And so you can say user error.
It's sad that even needs to be said, right?
All you want, but we need to get a way that there is no user error. Okay, so by the next court date, it's just going to be, as Mr. Khalil put it, dinosaur. It is what it is. Okay, it's a bone buried in the desert. Okay, it is what it is from this point to the last point. And so evidence.com is not workable. Okay, unless you can somehow bring someone in here that is going to tell me that they would be able to download whatever without any user error. Okay, so otherwise, if someone is going to tell you that there could be user error, then you need to find another format, either 100 computers or whatever you got going on. Okay.
100 computers. That sounds great.
So anything else about this electronic evidence? So you all are going to identify, that's y'all's to-do list.
And Judge, I think that was the purpose of our expert coming down and looking. I mean, we think it's all problematic. And that's why we had wanted our expert to come down, look at the original raw data on the police officer's drive, look at the original devices and say, this is a good copy. And so that was the impetus behind
Well,
our expert coming down.
Mr. Crody, you're backpedaling. So let's just put all that in the rearview mirror, okay? Y'all are going to say that this version, that version, this version, you're going to say, we have looked at this, it's problematic, it's got, you know, this megabyte, this terabyte, this, and just dump it, okay? Then you're going to file it, okay? So that if needed, y'all will have it. It will be a copy back to the state. It will be a copy to the court, kept under seal, okay? Your expert will have it, okay? That will be excluded. You understand? It will not be evidence, period. You're gonna communicate back. They are gonna then give you what their final version is in something that if it's 5 terabytes over here, it will be 5 terabytes over there. So you don't have to worry about it, but you'll have those other copies. So if it becomes necessary, y'all can compare it. You can raise issues. You see what I'm saying?
And their expert, yes, when we complete this, I've already reached out to council for future dates. We are happy to do an evidence view with their expert once we get this file and tell them what size the files are. They can examine the original data.
Okay. Do you see what I'm saying?
Yes, sir.
So let's put that in the rearview mirror. And I'll address that if you want to bring it to my attention about this canceling, whatever. But let's just vote. I'm not having any sanctions motion. I'm trying to get to a point where we can move forward.
Different
all right?
hearing.
Are you with me or no?
I'm with you, Judge. I don't think you understand the Herculean task that we have been faced with in this case.
I'm trying to.
Discovery.
I agree.
And now, as I think about this, you know, I understand what the court's trying to do, and I think that if we're just focusing on the devices, you know, there aren't that many devices.
I'm not focusing on devices. I'm focusing on what you all consider problems. Y'all have been telling me that y'all have been wasting time downloading this, downloading that. It takes too long, whatever. Y'all tell me what your problems are. And that's why I cut Mr. Cleo off, because I don't want y'all starting from scratch. We're too far in. What I do want to do is address the problems. If you have multiple versions, they won't be allowed into evidence, but you'll have them. So if y'all want to investigate to see if this final version, that what they are going to be able to potentially use, you'll have it, but it will be for exclusion purposes, a part of the record. Okay. There are 9 versions of Henry Tennant's phone will be filed with this court, will be communicated back to them and say, because they are not seeing what you're seeing. Okay. And y'all are seeing 2 different things. They think they're solving a problem, but they're creating more problems for you. That is why we have gotten ourselves in this little pickle. Okay. Because they keep saying, we're going to do it.
You know,
and y'all keep saying,
I don't know if it's a little pickle. I would say it's more of a big pickle. What do you guys think about the size of the pickle?
when they do it, it's a problem, and it's a big problem because it's a lot of information, a lot of evidence. And so we're scratching all of that. Y'all will still have it. Your expert will still have it. Whatever they give back, that is what your expert needs to look at, because all that other stuff that y'all have been doing is excluded. The only purpose in it is that when they give you whatever this final version is, y'all have the time, if you want to compare it, but it won't be admitted into evidence the way that it was. So y'all will have some confidence, hopefully, in what this electronic evidence truly is.
Personally, I happen to love pickles.
And I'm not gonna let these problems like sit around and fester. Okay. If I need to talk to whoever, this evidence.com, this next point, whatever, is a problem. It has been a problem from the outset of this case. And so we need to get into a form where it is rock solid that y'all have.
There it is. I knew it was coming. I remember thinking it was right after she mentions the pickle. So that's extra bonus there. There it is, rock solid.
This next point, whatever, is a problem. It has been a problem from the outset of this case. And so we need to get into a form where it is rock solid that y'all have confidence that whatever is being communicated is what y'all need to investigate and spend your time on, is where I'm at. Mr. Crody.
Judge, I understand you're right. And we'll comply.
What is the problem with that? Well, you're saying it's a Herculean task, and y'all have already downloaded whatever. I understand all of that.
Just in time.
But I mean, otherwise, just sitting around saying it's a problem, what would you suggest?
I have been concerned, and I remain concerned, and I do think that an index would be helpful. Okay, I think but if they can compare it to what we already have, that would be very helpful, because I think while there are problems with the devices, you know, our solution that we had was to send our expert in to get the original data. Like, that was our solution, to make sure that we, on behalf of Ms. Gardner, were not missing anything. Okay, that was our solution. We have not been able to, we know we spoke to the court about that was our plan. We have not been able to accomplish that with regard to the devices.
Okay, well, let me ask you this, okay? If you don't want to do what I'm suggesting and you want the expert just to come in and look at what they have, and you, Ms. Gardner, leave it the way it is, what Ms. Gardner's issues, I thought y'all had common issues, that is common multiple versions of everything. If you want your expert to go through all the versions that you have gotten and then go through potentially a final version, I'll leave that the way it is. What I'm seeing from Ms. Day is that you like the solution that I've given, which is I will suppress / exclude the multiple versions. You get one version back from the state, and that is what is going forward with Mr. Fernandez.
So the reason is because Shannon Day is representing Mario Fernandez Saldana, which is Shanna's estranged husband, right? And then, like, in terms of who's there in court, right? And then Mr. Crody is there in conjunction with Mr. Baez, right, representing Shanna, so they can have their own preferences. But why is Nightbot is so funny with these commands? Anyway, because we had that new command for DJ Khaled, but anyway, worked earlier. Nightbot must be having a little nap. Cute.
Mr. Crody does not. Y'all don't have to be on the same page. It doesn't.
And I'm not prepared to tell the court right now which way we want to proceed. I don't have the knowledge of what exactly we're dealing with to tell the court which way I want to proceed.
Who's doing the discovery for Ms. Gardner?
There are several people doing the discovery because it's so voluminous, but I think we need to.
Who's the lead on it?
Probably
Ms. Medina
and Ms. Rapetti. But we need to talk to our expert and ask him. I'm just not prepared to tell the court today that's an acceptable solution. I'm just not in a position.
How long is it going to take for you to talk to him?
Probably a few days.
My detective spoke with our expert. He did reach out to him when we got his email before he canceled his trip and asked him what format he wanted everything to be short. My detective has conveyed that information to me. I've conveyed it to our expert, and we are prepared to gather it in the format he wants and have an evidence view end of April, early May.
In what format?
He wants to look at the data he wants to look at the original extractions on their computer, and he wants a first copy of the original extraction, which we're providing to him. Both the raw data and the parsed data.
Okay. When?
I sent an email to defense counsel. Their expert said he would send us a hard drive because he wanted to look at the data before he made the trip down. And I sent an email end of April, but I think probably, to be realistic, sometime in May would be best.
No.
Hi, Judge.
Hello.
This is Michelle Medina on behalf of Ms. Gardner, and I'm sorry for the noise on my way to court. But I've been listening. I've been dealing specifically with the digital evidence.
Great.
And the issues that we're having, Judge, we provided the state with a list of all of the digital forensic evidence that they claim to have in their possession. And I've specified on that list what we just do not have. So it's not an issue of we received one version and we want another, is we do not have it, period.
So who y'all are hearing from right now, that's Miss Medina. She's there via Zoom and she's with the Baez law firm.
And so the goal was for our expert to just go and just retrieve everything they say they have and just get it directly instead of having to wait to get a copy, see if it's a readable version, and then relay it back to them. So I think the best way, just for sake of time, is just to have our expert meet with their expert and retrieve the evidence directly.
Ms. Medina, you said that how did you give them that list?
In Word format. I actually have that list and I can provide the court with
Why don't you do it in order to compel? So y'all, Ms. Gardner's issue is not multiple versions.
Well, we have multiple versions as well. This is just it's a side issue of there's evidence that we just do not have.
Oh God.
That's digital.
Why?
So it's two.
And it's also, is it the ones that you don't have, meaning that they need a taint review?
And now we get to a taint review. Thank you so much, Judge Kite. We have Rock Solid. We had Make It Bigger. There were some other things in the mix as well. Oh, the pickle. And then now we have a taint review. Wonderful.
No, it's not taint related.
It's not related to taint, guys.
Well, all right.
That's why I think because we're lawyers and I agree with Ms. Stifler, sometimes it can get lost in translation with the technical terms. That's why even my expert had said, let me just deal directly with your expert because they understand each other and just schedule a time and get it directly,
Okay, that I'm fine with that, okay?
Okay.
But I do want it documented some way.
100%, yes.
Like, I want it documented whatever you're missing, okay? So if you'll do that,
yes, Your
maybe
Honor.
as a motion to compel. All right. Mr. Karoti is the naysayer in the room about my solution. What do you think about the multiple versions is what I'm working on?
Yeah, no, I think that's a good solution with the multiple versions. My concern was more of what we don't have and delaying that process.
No, I'm not. Okay. We're thinking about different problems. Okay. So I'm on multiple version solution. Okay. Multiple version solution, which Ms. Day seems to be signing on to, and Ms. Medina, since you are.
The thing is the patience that Judge Kite has right now. When nobody understands the fucking terminology here, you've got two defendants with their separate defense teams. You've got people over Zoom. You've got the state, which is just giving everybody the runaround and not taking accountability and not providing any solutions, just providing excuses, really. And she's trying to fix all this, and it's a fucking mess. I mean, this is I don't envy her at all. Like, this is such a fucking headache, and she's being extremely patient. Wow.
In charge of it, okay, which is that whatever multiple versions you have of whatever evidence that you then, do you have an issue with the copy being filed with the court under seal? So, but y'all will still have all these versions. So whatever the final version is, you can compare if you want, but you know that those versions would not be admissible. Does that make sense?
Okay.
Are you with me or no?
So you're saying that you would receive a copy of our copy?
No. Y'all would make a copy of what you consider to be problematic. So have you seen the filing by Mr. Tassoni?
Yes,
okay.
I have.
So what I'm gathering from my questioning is that, so Defense Exhibit C on Mr. Tassoni's filing, okay, has, I think, hopefully enlightened the state as to what you all are dealing with.
Yes.
Okay. Because whatever they are looking at is not what you are looking at. And then that is what part of the problem is. And they keep trying to solve issues based on what they are looking at, but you are looking at something different. So my thought was you all make a copy of whatever you all believe to be problematic. And when I'm saying problematic, I'm not saying things that you have not gotten. I'm saying what you have already gotten. Let's say you've got multiple versions. Ms. Day has communicated what one of Mr. Fernandez's issues is that, let's say, and I've been using this as an example. I don't know this to be the case, but Henry Tennant's phone is a 5 terabyte on one version. It's a 3 megabyte
yes, that is
on.
Correct.
I'm sorry?
Yeah, that is true.
Okay, so that's where I'm at. Okay, are you with me?
Yes.
So that is what you would make, whatever copies you all have received, okay, you would make the copy of what you all have seen, meaning the numbers / files that is not what the state sees when they are, I guess, providing it to you, is what I'm gathering. So you all give it back to them. You file it with the court, what you have given to the state saying these are problems. I would exclude it.
Okay.
Okay. So we know that, let's say version 1, 2, 3, 5 terabyte, 3 megabyte, 4, whatever byte. Okay. Is excluded. Y'all would still have it, but the state then able to provide you with one version, okay, that would be indexed, whatever, that is what they're saying in a trial, that this is what it is the day that they provide it to you to the end of days, okay? That's what my proposal is.
No, I think, I guess my only concern is really the logistics of the copies because they're huge files.
I mean, I don't, why can't, instead of trying to, like what I'm saying, we break these things down into whatever they may be. For example, like, if it's one device, you get one hard drive, not some huge cloud, whatever.
Oh boy. Okay. That's just my I would want to have that conversation with Shannon. Because I think in this format, it can be done with specificity.
Right.
And there's already documents of that specifying, we received this on this date. this was the file name, this is what it shows. I mean, we have that written out. My concern is just providing chunks of the electronic format, just because just downloading it takes hours, sometimes days. So my concern is just now copying it. Could it take just as long? I don't know, you know? Copy.
The reason we did cloud-based nextpointevans.com is because it is a quicker, more likely to download properly and completely than hard drive to hard drive.
All right,
Huge
this is a
shut
capital
up.
case.
Yeah,
all right?
right?
I understand.
This is a
Yes.
capital case. This cannot exist in some cloud somewhere. It has to exist of record. These clouds don't exist.
It's just a conduit to deliver the discovery to them. The same way the portal delivers discovery from our office to the
Understood.
office.
Understood. Okay, so let's say down the line, this is a capital case. It has to be filed in a capital way. And so if it's never anything and it's up in some cloud somewhere, that doesn't make any sense to me, okay?
Which is the reasoning behind the state putting all this on a hard drive index and filing it with the court and then providing copies of that court exhibit to both defense teams. So that at least it's of record. The hard drive that we create and index will be filed as a court exhibit for appellate purposes.
Okay, so if there is ever a question about what they got as a defense team, how do we resolve that issue?
We can take, Your Honor, there's a way to take a screenshot of the, like when you open a hard drive, you'll see all the folders of how we received it from the state. And we could take a screenshot of that folder. It shows, you know, the size of the file. And then we can take a screenshot of that same, let's say, file showing a different size. And that way it's undocumented, it's visual, it could be in a list format.
Okay, that's fine, but Ms. Medina, that's not how it looks to them.
Right, but they can see how it looks to us.
Right, but they don't know what to replace it with.
I mean, I would assume that they have what they gave us.
They don't.
You know?
They don't. That is what the problem is. When they look at it, whatever. So we're still operating on Mr. Tassoni's Exhibit C. 20, 24, all these numbers is in a file folder. Okay. When they look at their file folder, it says subpoenas. For you, it says 2024 1, 2, 3, 4, 5, 6, 7, 8.
Right, but they should know that they gave it to us on this date. Like they should have. I mean, I am assuming that the state would have documentation that on this day we gave the government, and they see what they provided to us, and then we can show what we actually received through screenshots. I mean, that's just my initial thought process. But like I said, I really have to talk to Ms. Day to see.
Have y'all sat down and said, I click on this, it's this with the state?
Your Honor, that quite frankly was our plan for the deposition with Mr. Johnson.
Yes, correct.
We had lots of questions on just how to open files, trying to figure out if they were complete or not. I'm totally understand some of this may be user error and not download error, but I have no way of knowing that without comparing it to a correct and accurate file.
Okay. But what I'm hearing from the defense is you don't want to start over. The state wants to start over.
I mean, quite frankly, oh, sorry, Pat. Go ahead.
I think what we're seeing, Judge, is looking back through the state's discovery exhibits, they have been woefully vague. And I think it would be helpful for everyone if we had a complete index of what the state believes that they have turned over to us. That, for example, going to the paper sample, we have files that say Henry Tennant's jail calls. Okay, that's how they disclose them. We get them, and they look like a ton of numbers. Now, I know how many files are there, but if they're saying that they disclosed 27 of them, I would like an index that says they disclosed 27 of them. And so I can go back through, or even more detail, if they're willing to give us more detail. So I can go back through the files that I've received and say, okay, I have 27 calls. What I don't want is for them to give me a new folder that says Henry Tennant's jail calls. I have to click on and say, okay, there are 27 there. And now I have to open my file and say, okay, there are 27 there. Are they the same? That would be, but I do think there is value in an index, and especially if they can relate it back to when they turned it over to us. And then we have all the evidence.coms downloaded by date.
When you downloaded them?
We have them downloaded by date.
So this trail that Ms. Stifler is talking about, if she can compare it to the trail that they have?
And provide us an index and this is probably separate and distinct to the multiple version issue.
Well, we have not even finished that problem,
I know.
Mr. Crody.
But I do think there is value that our concern, and I think I speak for Ms. Day also, is you're going to give us a new hard drive, and then you're going to say, well, you guys are bound for that at trial. And if the state uses something on that hard drive at trial, we're like, oh my God, we never saw that. They say, oh, we gave it to you in the hard drive. It's on the hard drive. Well, that makes it that we have to start anew, and that's our objection. What we would prefer the state.
No, that is not what I'm saying.
No, I understand that. But what I think we prefer is that the state does give us a detailed index, and it includes when they turned it over, so that we know when we got it, and we can go back and cross-reference that, as opposed to doing a new hard drive. With regard to the digital part of it, I understand the court's concern. I do think there is value in what Ms. Medina was saying, in that if we can determine how large the files are and what we believe they reference, I think that would be that would. And then I think what happens is the state turns over a new copy of it, for example, Ms. Jensen's cell phone, and gives a copy to the court, and that becomes the copy that they will work off of trial.
This court does not need copies of the discovery. What I was proposing is that I keep copies of things that are excluded, so that y'all would get it back, and you would know that these multiple versions. I don't care if it's a copy. I don't care if it's a screenshot. That there is some reference in this court of what is excluded and what will be worked on. That is my thought.
Judge, I think the inverse is true, because if there was a disputed trial versus what was excluded and what was not, you would be able to figure it out you would inevitably have to go to the copy that they turned over. You wouldn't go to the copy that was excluded. You would go to the copy that was turned over to determine if the information was in fact turned over. And that's why I'm proposing that essentially there be a copy deposited with the court as to what they are going to, with regard to the devices in dispute, as to what that they would use. I don't know that providing the court copies of what the court is excluding.
Well, it has to be of record what you are turning over to the state, and then I would say that is not admissible, then they turn back over what is admissible. So we are not working off of multiple versions, that y'all would not be referencing some old. I don't care if it's an actual copy or whatever, y'all make a copy or reference somehow, like if it's too arduous to duplicate it electronically for the state. My thought was that if you did at least identify in some way that their expert could verify, and then we say that is not going to be the evidence in the case. Instead, the amended whatever index that y'all come up with will be the evidence. So we can just kind of cut all this off. That I'm trying to get to one version of whatever y'all are concerned about. That's what I'm trying to get to. Whatever I am operating, a little bit in the dark, that I don't know what these things are or how it's best accomplished. But what the problem is that what I'm seeing on the filings is that what y'all are seeing and what they are seeing are two different things. And so if I don't speak, French, you saying something to me means nothing. Okay. And that is what has been going on. And so I'm fine. I'm not going to, I'll wait. Okay. I'll let y'all have the conversation. I'm not going to wait y'all are not going to get all these long pass dates anymore. Okay. Because it's too problematic. If I want answers, it's going to happen quickly, because, we are too far in. So that is what I'm thinking. So on y'all's notes, let's start from the top. Okay. Problematic, multiple versions of electronic evidence. All right. From what I've heard during the course of this case management hearing is that we need to get to one version. I will let y'all talk offline about it. I'm giving you my potential solution or thoughts about it. You all have the majority of the working knowledge, okay, to get us, which is any goal in any criminal case, to one thing, whatever that thing may be, one. And so I want you all to share however you believe to be appropriate and accurate, so that you all can get on the same page of what is the problem and then a potential solution. My solution is that we scratch just the problems, and I don't want to work. What has happened in this case is there's so much, and then y'all are dealing with so many problems. To me, it's step by step, one by one. So we are going to first deal with the multiple version electronic evidence problem. I think it is a great idea for the state to index everything. Wonderful. But what I'm only suggesting a solution to at this point in time. Whatever y'all want to communicate as far as like trial exhibits or indexing, do it. Okay, do it. However, what I'm going to.
He said, do it. Hang on. Woo. Hang on.
Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it.
Also.
Hard as a rock, freeze thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
To manage at this point in time our problems. Are we with each other? So you talking about indexing, great. You talking about organization, great. I'm not worried about that. Y'all are professionals. You can handle that. I'm going to deal with evidence problems. Okay. So number 1, we'll all write the same list. Evidence, electronic evidence, multiple versions. However y'all see it to be appropriate, the defense needs to communicate the problem electronic evidence to the state of Florida in the form that the defense has. Okay. Whatever that may be, like how they gave it to you and how it is problematic. You understand? Like I'm looking at C. We'll use Exhibit C as an example. If the state looked at Exhibit C, okay, are you able to tell what that is in your file?
I should be able to search it by the file name within evidence.com.
Okay, great. So if that is, so let's work. I don't know what this stuff looks like. So I'm just using Exhibit C. So if you all are able to cross-reference Exhibit C with whatever is in your file and you are able to index it some way, make it make sense along the disclosures that have already taken place, great, that will be the solution. If it is not, then we need to scratch the way it has been provided and then provide the final copy. And then it is what it is. And so I will let y'all offline talk about that. Okay.
It is what it is.
So
hey, yeah, we got to Ipsy Dixit. Hang on. It is what it is. Spelled this way. There we go.
That is going to be to do number 1. Okay. Then number 2 will be you all, Ms. Medina, on the missing electronic evidence. Is that the same for Mr. Fernandez or no?
It's been a while since me and Michelle have compared notes on what.
Okay, well, y'all can let me know. So let's, number 2 on the to-do. Missing electronic evidence. You all identify it, and it needs to be of record. So y'all's emails back and forth mean nothing to me, okay? Motion to compel, that will put the state on notice that you all are missing these things to the extent that it has been referenced in some former state disclosure and y'all have looked at it and you cannot find it. Show them where they have disclosed it, and then I will handle that at the next court date. So file that, okay?
Will do, Your Honor. Thank you.
All right. Now, to me, problem number 3,
There's so many.
I think, I can't remember the date. I believe it was back in 2024 where I want to know, so this electronic evidence has, to me, almost like overtaken everything else that y'all have been doing. Y'all have been working, right? And you've been deposing witnesses and all of those things. So at the next case management hearing, okay, what I did my best to count, cross-reference witnesses and physical evidence and things of that nature that have been done and need to be accomplished. Okay, so I want just a nuts and bolts analysis from both the state and the defense. What is left to be done as far as like physical evidence? And when I'm saying physical evidence, I'm saying like, is there any, I think I've asked this question before. There's nothing forensically that's outstanding in this case, correct?
There were some forensic testing requested by Dreiser Hill firm. I spoke with the ATF agent yesterday. They had anticipated completing that I gave them a deadline of March. So they know it should be completed shortly. So that's it though.
How was that requested?
I requested they complete the forensic testing by March because.
No. So the defense asked that.
There was a particular swab that they wanted DNA testing completed on.
But you didn't file a motion?
I just agreed to it.
Okay.
They can file a motion and you can, for record purposes.
No, I mean, okay.
I'm happy to file, but the state did agree. So
And we had some other swabs submitted.
save you one.
They had asked for all forensic testing when we had the October trial date. We completed
Okay.
6 months ahead. So
No motion needed. Okay. However, what I would like is some documentation, because this is the first I'm hearing of any of that. Okay. There needs to be some type of documentation, either a consent order of
Understood.
what you all, what was requested and what was,
Obviously.
or some type of, there needs to be some type of documentation of the request and then the agreement of the evidence that was tested.
I did list the swabs on a supplemental. I can't remember if I parenthesized it requested by defense or not, but I can file something reflecting that. When I receive the testing and disclose it, I can put that in the supplemental.
Okay, that's fine. So whatever evidence was requested by the defense that was tested by agreement by the state, when you get whatever results, that needs to be documented some way.
Yes, Your Honor. That should be shortly forthcoming. ATF, I requested it be completed by March and I followed up yesterday.
Okay. Now,
And
the witnesses.
Yes, for your Honor's information, I'm looking at Ms. Gardner's case, docket line 318. In December, I had filed a state's exhibit regarding depositions. and
Right. I tried to go through that.
I listed all the depositions we completed in 2024.
Right. And then I did look at that. And then also with some of them were completed later. And then there have been depositions since that time
Yes, Your Honor.
that have not been documented about who was completed. What I'm really asking is what work is left to be done witness wise. Okay. Next court date.
Yes, Your Honor.
I need an outlook for that. But it looks like, I mean, y'all have been working diligently through the witnesses. And the other problem that I wanted to, I'm going to put it out there. I want an answer. The defense has filed requests for specific discovery that is longstanding in this case. And the state needs to respond by the next court date. Do you know what I'm talking about?
I think there was a request for, we had done one filing. I will go back and make sure to respond to all outstanding requests for specific discovery. I think there was a
So-
request for some body camera footage in regards to Henry Tennant's arrest on unrelated charges, which I'm happy to provide and we'll file a response.
I think it's in Mr. Fernandez's case.
Mhm.
All right, then the one I'm referencing is one in Ms. Gardner's case. I'll respond to whatever's outstanding.
It was what I brought up earlier about jail calls that exist. And they also wrote in Mr. Chisoni's filing that they have done a public records request, but to the extent that the state has memorialized those.
Yes, ma'am, and we just have not had an opportunity to respond to Mr. Tistoni's latest filing, and we plan to do so in writing.
But it was referencing what was filed
Yes, ma'am.
way back. So some of the, so once you all get together, you meet about whatever the multiple evidence, the missing evidence, the consent apparently is not an issue. If the physical evidence has essentially been examined or whatever, I did see that, I guess, some of these experts and things like that have not been scheduled for any deposition yet.
We have not scheduled what I would say would be, the law enforcement that played an integral role in investigating the case.
All right.
That's really who's outstanding.
Okay. And then, but also these forensic experts, both computer.
Correct, because we haven't, we
Right. Well, I mean, that makes sense.
Yeah, we've been.
Oh my God. Say it. Sorry, I'm just laughing. Say his name. Say his name. I'm talking about Mr. Green. I wonder if it's Richard Green.
And the DNA testing still ongoing.
No, what
There's some-
Is there?
Yes, I'm still.
Oh, the ones that were requested.
Yes.
Okay.
It's the same analyst, and there are some experts in regards to cellular site data
Hmm.
and location data,
Oh, Twiz, did you hear that? Music to your ears?
FBI and ATF.
Is there any issue with wires?
As far as
We've been spending like,
I mean,
with
we're-
the
we're gonna fi-
devices.
We're gonna file a motion to suppress the wires because we think it was a bad wire. If that's what the court means.
The wires.
Okay. Let me.
I don't think we knew about
I'm not
that.
asking. That should have been a better question.
I
What
don't
I'm
think we knew about
asking
that.
is there any issue with disclosure of wires that you all are able to? I'm on discovery, not motion. So, is there?
To our knowledge, what I can tell the court is we have received many recorded wire intercepts that.
I saw one. It's 230.
Yes, Your Honor. And I also provided, they're transcribed. I provided transcripts to defense counsel as well.
Is that disclosed?
No, I didn't specifically list transcripts.
All right.
I can do that.
Look, whatever you are giving over needs to be of record. And so if this is in this master index, that would be great.
That's
Okay.
fine. I'll let the court and defense counsel know. I am organizing and planning to file a chart with specific statements of both defendants. I plan to introduce at trial. I've been trying to be specific in their statements and my disclosures, but there will be a master list with a motion for pretrial ruling on admissibility for some of the statements in regards to
Master list. I have one of those.
So they'll have,
Over.
prior to trial, an outline, all the statements of co-conspirators, all the statements of co-defendants, all the statements, specific statements of defendants I intend to try to introduce at trial.
All right.
And that would include the wires, any digital evidence, reports, interviews, that sort of thing.
So this, I do think the index would be very helpful for everyone. But what I'm trying to do is like on the back end of whatever index that you all, before you start creating something new, that you know where the problems lie, so that the index that you all create for whatever reason is addressing their problems. And I know that you all have been trying to address problems, but the problem is that y'all are not on the same page about what is going on. And so when you get the list of problems that the index,
the problem is that when they try to address problems, they make the problems worse. They make mistakes.
it'll be great. You can say that issue is addressed on index line 1012. Okay. But what I really want to do is address the problems. And so if y'all want to have some master index, great. Okay. But what is at the forefront are these problems, these problematic things. The majority of it is in electronic information.
I understand, Your Honor. I agree. I think it's prudent that we put it in writing in the record instead of just doing emails. And I will say, I want the court to understand, Ms. Day and Ms. Medina have been working very hard and collaboratively with the state. It may not seem that way from this hearing, but I do think that all three of us have been really trying to solve these problems.
I don't take that at all. I think what I do believe is that y'all are somewhat on the same page, but not totally on the same page. And that is, in this court's perspective, very bad. Okay. Very bad, because evidence has to be what it is. And so like if people have multiple versions of something, there's no reliability in what is being put forward. There's no reliability in what they were spending their time on.
I think, again, to me, it's like, yeah, where did they go wrong initially this time around, round two? I mean, evidence.com. Need I say more?
And so what my thought is, and what is so important, especially in a capital case, that it is what it is. And so like, that's where we've got to get. We are not there yet. I don't think we're necessarily far off. And that's why I want the defense to put not in, but like orders to compel, like, so that it is specifically identified what these problems are. And then I'll get to whatever else y'all want to litigate, but like, so that I have like kind of a clear understanding honed down into what actual electronic files / electronic evidence is, where are the multiple versions, that listing, so that I can order responses to it in a timely fashion that does not frustrate the path of this case. So that's why, like, starting all over, I don't necessarily, some of this you are going to have to, but hopefully it will be just on a few things, maybe, not totally.
Definitely. This is in Florida. This is in Duval County, Florida. So Jacksonville. And, again, the mess of this, right? Like, this is not how they roll in Leon County. This is not how they roll in Orange County. You know what I mean? Like, I don't know what's wrong with this prosecution team, but yes. And also one of the other lead attorneys for the state is, like, the DA is not there. as well. But of course, they have support staff and all that. I mean, totally shouldn't appear like rocket science. Couldn't agree more. Yep.
Okay. All right. So how long is it going to take for y'all to do that? And then I want whatever, so that I want the state to confirm that it is 230. That's what I saw in the disclosure is what it is. Okay. With your index. If y'all don't believe that to be an issue, fine.
On the bright side, at least the sound.
So disclosure wise, then, the state has disclosed certain subpoenas. I'm assuming that this index would say, like, I know that you have written a supplement disclosure about subpoenas and response / evidence to it. This index will address those issues in a more succinct way.
Yes, Your Honor. And also Ms. Day's numbered list, I can either incorporate that into an index or if she's going to file that as a motion to compel, I'll respond specifically. There are times where we sent subpoenas and got no returns, and I try to file it to reflect that. I know it's hard to disclose that.
Right.
In a way that makes sense.
Right. So I don't necessarily, if you have tried to do it, if it is in the index, that it needs to read almost like a sentence. For example, like I'm looking at, let's say, community first subpoena, date subpoena, whatever it is, no response. And then that should hopefully, in a line of things, say that this was the date of issue. This is the return date. Result on the subpoenas, because there's so many subpoenas. I counted just on this first disclosure, I think I counted like 40, 44 subpoenas. Okay. And so if the state could line those up in whatever index y'all create for this master, that would be, in my mind, helpful.
A master, a special master.
So we'll just stop it there. So to me, I have two top priorities, which is what will be the focus of the next, which are these multiple versions, so that if you need court intervention about how we would deal with it, if you all show them how it is, like if it's screenshot, great. If it's, you have to actually give it to them, fine. But I'll look to you all to see how you all are able to potentially resolve this. If y'all are able to resolve it on your own, okay. If you need me to exclude / suppress the one and then y'all just start all over, that's what I need to know at the next court date. Okay.
Your Honor, I do have one question. I understand the court's priority is the devices. That is a huge, substantial amount of the evidence. My notes do reflect there are about 198 subpoenas, and I do believe.
Well, I was only looking at that one exhibit. So.
I have them all listed. I do believe we are missing about half. So.
Okay.
Oh dear.
We see it as like an equal concern to the devices.
Wow.
Subpoenas.
Yes.
Okay, got it.
Wow.
So I didn't know.
All right, so do that in a motion to compel. You list what, have you all referenced, like, let's say subpoena A has a result and you have that? So the devices or the subpoenas where you don't have corresponding response, list that in a motion to compel and put the state on notice.
Okay.
Okay.
Yes,
not an email.
Yes, Your Honor.
Okay. So then everyone is operating on the same page and the state can go through whatever, and then we'll deal with how they have responded or how they intend to respond. If they have no response or what. How long do y'all need to do that? And don't say 30 days.
I know. I'm in a all-week trial next week.
Can someone else help?
Yes, we have a paralegal who's working on this with us.
As soon as we get the list of, Your Honor,
Right.
of what they believe.
Microphone. Microphone.
No, I apologize. As soon as we get the list of what they believe they need in the motion to compel, we will.
How long do you think? From the defense, how long will it take for you to compile it?
I guess.
And do it in do one. Okay, so from this hearing, this is what is missing, right? And do it just in sections. So then it can be communicated in the state and we can then deal with those.
Your Honor, my hope is that we have scheduled a discovery conference on April 17th amongst the parties. We hopefully will be able to have the answers by that time, if not sooner.
All right, you're just shy of 30 days then when I could probably do this again. All right, the other thing, so if you all are going to have those conversations, okay, if it becomes necessary from y'all's perspective to just have the experts talk to one another, or schedule on-site collection or what, I don't know what y'all want to call that. I don't know. If you all will select a date and time, I'll put it in order. So then there's some teeth behind it. Okay.
Perfect. Thank you, Your Honor.
I mean, I'm operating a little bit in the dark because I don't know what these things are. I don't know kind of what it takes, but if you all I appreciate y'all's patience with me because I'm trying to understand it, but as to the extent that this court can help kind of unravel some of these issues, I'm happy to do that. And y'all, what I do intend to do from this hearing is designate this as a priority case. And as a priority case, it would take precedent over anything I have on my calendar. So if you all need me, I will make myself available at a drop of a dime. Okay. So there it is. Courts, actually the chief judge has made this a priority case. I will incorporate that / memorialize it in order so that you all know that if you need me, I will be here. You will have the court time. I don't want these problems or miscommunication or whatever might be occurring to fester for days and days and days. If y'all get to a meeting and you can't get it resolved, you can have time with me the next day. Okay. I do not want these things to kind of go like this. We need to, and to me, it takes maybe sitting down, hashing it out, and then I will intervene if I need to. I'm not going to intervene if I don't need to. So I will do that so that you all know whenever you need this court, I will be here.
You've got Judge Kite. Oh my God,
Right.
the timing of that.
Thank y'all for your time. Do you all have time? I have something, but I will reschedule it as I've indicated, maybe April 25th after y'all's meeting.
I'm out of the country that week, Your Honor.
Out of the country? What the fuck are you doing, ADA Stifler, going out of the country?
The date and time, how written in stone is that April 17th date of a discovery meeting? I say I come before that. I can come in before that.
She wants to come earlier,
To
guys.
the answer. So I'm available next week. I'm available the week of April 7th, and y'all tell me a time. What isn't the bias firm unavailable?
Through April.
I believe it was April 1st, Judge. I know I'm unavailable the 9th, 10th, and 11th doing the death penalty CLE, so I need to get those hours for my certification.
Right.
All right.
Your Honor, I'm in an audit trial next week, but maybe April 8th, that Tuesday.
Okay.
So the dates again were April 8th, 9th, and 11th?
Mr. Carodi said he's unavailable the 9th, 10th, and 11th. He's in a death penalty CLE. So right now, y'all can have plenty of time with me next week.
I think Ms. Stifler said she was on
Oh, she's in a trial.
I'm in a trial in front of Judge
There's
Kite.
nobody else that could just get answers.
I can get answers and relay them to co-counsel. If that's when Your Honor wants to set it, somebody can be available.
the 8th. I think the 8th would work.
Everything be happening at the beginning of April, yo.
If we do the 8th, I'd have to do early morning because I have 4 trials set. One is a speedy issue. So I could do special set at 8 a.m.
I can do that.
Yes?
Yes, Your Honor.
All right, y'all got it. April 8th, 8 a.m. special set. Case management hearing.
That's to see where we are in the device.
Yes, and then from that point, once y'all hopefully have figured that out, if y'all want to proceed with the sanctions and things of that nature, I would schedule at that point. That will give the state time to review Mr. Tissoni's latest filing, and y'all can tell me. And like if you want partial review, or you let me know at that point in time, and I'll schedule a hearing. Okay.
Yes, Your Honor.
And one last update, we did receive an email late yesterday from Mr. Gano. He was able to complete the filter procedure on Ms. Gardner's Apple iCloud, and he's prepared to send that to defense counsel for review.
I thought it was the phone.
When he says Apple phone, he means
Oh
Apple
God.
iCloud, I believe.
Oh God.
I guess we'll see when we see it.
See, y'all are talking
God.
2 different languages. All right. See you.
So,
All right. We'll see y'all next time. April 8th, 8 a.m.
Wow. Wow. All right. Well, hopefully we'll see what happens, dude. Attempt number 3 to get this discovery to work without leaking again attorney-client privilege information. And wow. Okay, so they will be back on April 8th. It'll be a busy week next week or whenever that is, the week after, whatever. I guess there's 31 days in March. But anywho, we will be back later tonight with I don't know yet if we're going to be doing BK or Lori Vallow. We'll have to see. Maybe we'll do both. But again, I have those Lori Vallow docs, and we're going to also watch the interview with Colby. And the next BK will be the 911 call, expert witnesses, the dollhouse, and and DNA. So that will also be coming up as well. But other than that, that'll be it for this one, guys. So I appreciate everybody being here. Anyone who's less familiar with this case, which is many people, understandably so. There's a lot going on. I have a playlist for this, of course, as always, with everything else that I'm covering. So if anyone wants to get caught up to speed, everything that I already have out for this one, the timestamps are all done. The only ones that I'm behind on for timestamps, I think, are the Murdoch streams, but everything else is caught up to speed with timestamps too. So, but other than that, thanks so much for hanging out with me again, guys. Love y'all. And I'll see y'all next time. Squirrel out.